They're getting a little bit better.
He just got 9 degrees.
Live long enough and we just get
So actually, I looked up the video and it was 2.5 hours long. Wow. Really long stretches, but not like that.
and about the last
No, this is after the chamber music. No, I literally.
the chamber music guys were good.
Really were.
Is that the one? There's a really big giant, and essentially across the road.
My car was years ago. That's when it was. Started. So it was a great group, federal program, train well.
So basically, like 2 o'clock means 2 o'clock.
Well,
They have that actually.
Bowden got handed.
They're weird about that.
Second full year down. Yes. No, it's actually. Give me time to prepare. So when did you get it? He is the case of friends. Yeah, so she's we're about 10 blocks from each other.
And then
Yeah. So if you walk through her road, you make right through that you go another 10 blocks out to the left. My dad
basically wide enough for one enough traffic.
oh, how lovely! That's a
Accelerator.
apparently there is.
I feel like in the car commercial.
Why don't we get everybody?
Yeah. Exactly. Right. That's fine. Okay.
Josh has heard the story in some great detail. Probably run into
We could be here for now and then come up when after he's done. Good to see you.
I swear.
I just said six. That way you don't have please.
We have an older person. We actually places
It's never happened. I've been teaching enough classes. It never happens. Unless it's standing alone, and then people have years to stand back.
Okay, so we'll sit here and
Sit up all Bill.
all right.
What we're thinking of is order of service, which is Jim, Bill first, then Jeff, and then
did you? Okay, well,
can see
I
it.
can see. You see the train. He wrote the notes on the train. And
Like, shows you the quality of
read
like.
what you write on the train.
The opening to you guys hear your remarks.
Yeah. We didn't know. Yeah.
Rightfully so.
He's here just trying to be right this way. Salad. It was like, it was the fall forum. With like 7 speakers. I was 7. It was a 12-minute limit. There's no way it's you got Billy was talking about lunch that you finish in 12.
Right, just, you guys, when you speak, if you like, if you want to speak at the podium, you can, or you can simply sit.
I think it's a small enough group.
Okay,
That,
please.
yeah, is that okay with you?
I just want to lead off, so I want to do, you know.
How are you doing?
Right, right. Right now,
I
you're
don't want to set it better than others. Like,
Well, they're very difficult people jobs.
I know we're antitrust lawyers.
I'm Bill Kovacic, and I'm on the faculty here at the Law School at George Washington. And on behalf of Danny Sokol, who you'll see more of later today, we want to thank you for being here. Danny, of course, is on the faculty at the Levin College of Law at the University of Florida, and we're delighted to have you here today for our topic, which was it all that bad? The inspiration for the program is the extensive discussion about the quality of U.S. competition law over roughly the past 4 decades. It is a fairly striking body of commentary. It's not unusual to have sharply critical accounts of competition law at any one time. That's been a feature of the U.S. system from the very beginning. But it's not simply the occasional comment, it's the extent to which it's attracted extraordinary attention. The polite version of the criticism is that competition law, basically beginning in the early 1980s to the present, has simply been inadequate. The harsher, less polite characterization is that the system failed and failed badly, particularly in its treatment of mergers and in its treatment of single firm behavior. This is not completely unique to our U.S. experience. I would say if you look back through the whole body of literature, going back to the early experiment in the U.S. with competition law in the late 19th century, you see a recurring critique along 3 lines. There is a highly critical narrative of inadequacy that goes back to the beginning. Just to pick a prominent exponent of this point of view, Teddy Roosevelt. Teddy Roosevelt, who's often associated in the modern assessment of competition law as being a hero in the field, by the time of the 1912 election, he turned decisively against antitrust law. He was a caustic critic. He had vicious comments to make about the quality of the Standard Oil divestiture package in 1911. He ultimately said that the pursuit of competition law as a focus of national policy was misguided, that we should not try to dismantle large corporate enterprises, but to subject them to comprehensive economic oversight in the form, in many instances, of public utility style regulation. His critique was part of a recurring set of statements of concern about the adequacy of the entire system. And to do a search of the literature on competition law is to see this inadequacy narrative coming up again and again and again. A second critique is that its perspective has been too narrow, that rather than trying to deal with specific failures of the economic system, that it should take on a whole host of other concerns, dealing with public policy, dealing with the well-being of workers, dealing with the well-being of their communities, dealing with economics, environmental sustainability, that a narrow focus on what is often called consumer welfare is far too cramped in understanding what should be taking place. And the third basic observation is that what's needed is a much broader program. much more ambition and boldness from the competition agencies. Again, one doesn't have to look very far, just a quick collection of clips from the last week or so. It's a Martin Wolf column in the Financial Times from the 15th of November titled "Taming the Masters of the Tech Universe," where this very distinguished and thoughtful observer of economic affairs closes by saying, "Policymakers must get an intellectual grip on what is happening, and the time to begin such an effort is now." It's a rallying cry for a much more probing examination of business behavior. The Financial Times, which is simply one, The Economist, another, that's joined this chorus of commentators. A story, again, from the very recent past called "Capital Punishment. America's tech giants could eventually receive the kind of scrutiny that banks fared after the financial crisis." And a Financial Times editorial, "Big tech rolls on and the antitrust regulators roll over." Continuing failure to come to grips with serious concerns in the economy. To get us started, I want to go back 40 years, almost 40 years to this date, to November 18th, 1977, to see how many of these themes run throughout the history of our field. Mike Perchuk, who was then the chairman of the Federal Trade Commission, gives two famous speeches in 1977. One, which is the November 18th address, is given at what was then a premier competition law conference called the New England Antitrust Conference, hosted in Boston. This was Mike's first consciously expansive address about what he saw the role of the FTC in competition law to be in the future. He gives a subsequent talk in Atlanta in December to the Association of American Law Schools Antitrust Group, where he lays out his vision for what Section 5 of the Federal Trade Commission Act could accomplish in pursuing the goals that he set out. It's a striking assessment of competition law. Just to quote you a couple of memorable passages from his presentation, which in many ways could have been written today. There is a widespread perception that antitrust has failed to deal significantly with significant problems. In the clear, cold light, there appears to be a failure of philosophy, a failure of resources, and most important, a failure of political courage, of will. His prescription was a dramatic adjustment in the focus of competition law and policy, to take on a host of policy concerns that ran beyond a narrow definition of economic welfare. In 1977, Mike said, "No responsive competition policy can neglect the social and environmental harms produced as unwelcome byproducts of the marketplace. Resource depletion, energy waste, environmental contamination, worker alienation, the psychological and social consequences of marketing-stimulated demands." The solution was a dramatic reconsideration of what competition law and policy ought to do. Mike talked about a number of other institutional adjustments that he would suggest: a reorientation of the research program, a rediscovery of Section 5 of the Federal Trade Commission Act, where Mike said that is part of the mandate of Section 5, which has been largely dormant since 1914, but which is central to the implementation of an effective competition policy in the last quarter of this century. Mike's prescription in many ways foreshadowed in a dramatic way a number of the themes that we see expressed by academic commentators, by think tanks, and indeed by journalists today. And in many ways, the FTC had set about such a program, especially dealing with large corporate size. Mike's critique of inadequacy is curious in view of the fact that the FTC was engaged in two major campaigns, one to restructure the breakfast cereal industry, the other to restructure the petroleum agency. It was running two major predatory pricing cases. It had just begun the assault on the American Medical Association's advertising guideline restrictions, an assault on the distribution mechanism used by the soft drink industry. That is, if you were to step back and to look at the agenda of the enforcement agencies, not to mention IBM, not to mention the AT&T case at the department, you would have looked at that and said, that's a pretty full plate. Mike's critique was, it was barely getting started, not nearly enough to set the program on a sensible path. I suppose when we look at the program, Mike's comment, the historical concerns that I think one would ask in looking at the current program are, first, is the description of the existing program so dismal, so appropriately dismal, which is part of what we want to address today. Second, if you were going to ramp up and do something dramatically different, would you have the capability to do it? And I think the experience of the FTC and the department in the 1970s is a sobering experience to reflect upon. And last is the kind of political response one gets when one does these kinds of things. In my early years at the FTC in 1979, 1980, the agency was placed in the equivalent of what might be called political bankruptcy. I recall 2 days being sent home because the Any Deficiency Act, as interpreted by the Department of Justice, dictated that because we had no outstanding appropriations measure in place, that we had to go home and cease operations. And there's a sense that things turned decisively badly when Ronald Reagan came to Washington. It's the last day of the presidential campaign in 1980. It's the final day before the balloting takes place. Walter Mondale goes to Battle Creek, Michigan, headquarters of the Kellogg Corporation, and gives the following talk. He says, if you, the people, re-elect myself and Jimmy Carter, we assure you that we will seek measures to prevent the Federal Trade Commission from carrying out its remedial aims in the cereal case. Not in our entire history have we had an instance in which a sitting president and vice president have promised, as a condition for re-election, that they would seek to forestall a pending case being brought by the Federal Trade Commission, simply to block it. This is before Ronald Reagan came to Washington. By the way, Reagan gave a speech and said, I'll do the same thing at roughly the same time. But in many ways, the grief that the FTC faced in 79 and 80 took place when the Republicans did not have control of the legislature or the White House. And I suppose a question to pose is that if you ramped up the program dramatically again, why wouldn't this happen again? Why wouldn't the political feedback be similar, especially if you expand the focus of what the agencies ought to do? We have 2 panels today. Our aim is to look at in 2 groups, although we expect our panelists to move across these artificial boundaries. First, to begin by talking a bit about goals and the treatment of large corporate size, and then on our second panel, to look at proposals that the basic statutory framework itself be changed, expanded, be made more robust, the case law be adjusted, the doctrine be changed, and that the treatment of single firm behavior, other forms of conduct, and merger policy be adjusted as well. But we give our panelists in the first session certainly freedom to look at these issues as well. We've asked that our panelists start with a 5-minute or so comment, just to put a particular idea on the table, and then we expect that we'll have a discussion as well as interaction with our audience here. For our first session, and the logic of doing this is we wanted to bring back people who had major enforcement responsibilities in the period in question. Thus, was it all so bad from 1980 to the present? With us here, Jim Rill, formerly the head of the Antitrust Division of the Department of Justice, Jeff Schmidt, who headed the Bureau of Competition of the Federal Trade Commission, Aviv Nebo, chief economist at the Department of Justice Antitrust Division, Bill Baer, who, like Jim, held the position of Assistant Attorney General for Antitrust. We've asked all of them to reflect on the thesis of inadequacy, to address their views about whether policy has been undervalued for what it was, and to think about what kinds of adjustments, if any, they think would be appropriate in light of the critique we've heard. And I'll ask Jim, could please get us started.
Thanks very much, Bill, and I appreciate your opening comments. I appreciate also your comment on some of the early speeches by Mike Perchuk. As I'm sure Bill Baer is well aware, later on in his tenure at the Federal Trade Commission, Mike Perchuk made the comment, I have taken a bite of the Chicago apple. So maybe wisdom comes with time. I guess the question is, do the antitrust laws need to be enlarged to go on to considerations other than consumer welfare and the preservation of opportunities for innovation, to take into consideration labor welfare, environmental questions, First Amendment issues? And I answer that question with a resounding no. As Bill's opening remarks suggest, I have a terrible feeling of deja vu, as we have a lot of drum beating now for expanding the scope of antitrust. I go back to the days of not only these early speeches by Mike Perchuk, but serious Senate hearings on concentration run by Phil Hart, where the theme was concentration per se, bigness is badness per se, and we need to amend the antitrust laws in a way to take care of that. Intervening, following those episodes, we had major studies taking place. An early House conference that was run by Brosen and Demsetz in the late 1970s began to raise questions about the structural paradigm. Articles by Judge Easterbrook, then Professor Easterbrook, in the Texas Law Review, The Limits of Antitrust. The landmark book by Bob Bork, The Paradox of Antitrust. All of these had an influence to develop into what I would like to say a continuing dynamic, with the emphasis on continuation across administrations, across political parties, towards an improving focus on consumer welfare and the mechanisms for antitrust in dealing with the consumer welfare question. I think the landmark start was with the Baxter Guidelines, Horizontal Merger Guidelines of 1982, which started with, still basically, if you look at them, very heavily related to structure, but can't take other considerations into account. In 1992, we came out with another set of international guidelines, building on but not replacing the Baxter Guidelines, where we had other considerations such as other factors than structure, making more detailed analysis of entry, and adding the concept of unilateral effects. And then come 2010, we had a new set of guidelines which raises questions as to the paradigm of market definition and attempts to undertake a detailed factual analysis of how the effect of a merger might be, looking at the market as it is or as it is prospectively going to be, rather than the proxy of solely the proxy of market definition. The emphasis I'm making here is one of continuum. And what has happened with these guidelines? What has happened with merger enforcement? In my own experience, we brought major merger cases. We brought a settlement in Bank of America, Security Pacific, where we got the divestiture of numerous bank branches. We adopted unilateral effects analysis before the unilateral effects guidelines were issued in the Procter & Gamble Pepto-Bismol attempted acquisition of Maalox. The drumbeat goes on, and I think Bill and others are very well prepared to talk about the effectiveness of merger enforcement that's gone down through the last few decades as being both effective and reasonable, focusing on, I think, the paradigm of consumer welfare and the preservation of innovation. More difficult questions arise, of course, with respect to Section 2. Section 2 has enormous complexity, and one needs to be very careful in the administration, the enforcement of Section 2, and the counterpart, Section 5, to be assured that enforcement does not attack practices which are themselves competitive. It does not forestall innovation. And I think there's been a sensible approach to Section 2, by and large, by the agencies over the decades. I think a great debt is owed to Tom Barnett, who in a speech to George Mason Law School program when he was in office, drumming very hard on the extent to which caution must be taken in Section 2 enforcement so as not to forestall research and development. Tom subsequently addressed the OECD, the Organization for Economic Cooperation and Development, and said to his global counterparts, we must be careful that we don't step on pro-competitive, pro-efficiency, not anti-competitive conduct in the enforcement of single firm, dominant firm conduct. I think that the landmark there that shows that this is not a prescription for non-enforcement is, of course, the Microsoft case. And I think there the Court of Appeals properly reviewed the analysis, reviewed the facts of the case, and tried to draw a balancing between the pro-competitive and anti-competitive conduct that was involved by the firm that was then believed to be dominant in the operating system market, and came out with a solution that ultimately resulted in a decree that I think most people would agree made sense at the time and is a demonstration of the effective enforcement of Section 2. I think at the same time, down the road a little bit, we had the Supreme Court decision in Trinco, which raises some of the danger signs, some of the yellow flags, if you will, as to over-enforcement of Section 2. But the fact that there is caution to be exercised is not a prescription for non-enforcement, it's a prescription for enforcement based on the paradigm of consumer welfare and preservation of innovation. When one goes beyond that and one looks at labor welfare, environmental concerns, in many instances, those concerns, some, for example, labor welfare concerns, may be inconsistent with, not merely different from, but inconsistent with the notions of consumer welfare, the foundations of consumer welfare. So one has to be very careful not to undermine antitrust by trying to add to it factors which are not germane to what we traditionally think of as antitrust, and it'll result in what could be anti-competitive term. I think that the DOJ's Section 2 report, one doesn't need to necessarily agree with the conclusion, but there's a great wealth of information in that report that I think lays out a good foundation for the enforcement of Section 2. And again, the beat goes on. Just last week, Assistant Attorney General Del Rahim, in an address at the University of Southern California, undertook to draw the line as to when standard development organization conduct would raise question under the antitrust laws, and whether certain practices in the licensing field would be of concern with antitrust. And he properly, I think, raised a question of whether or not collusion might be a concern, or is a concern, when looking closely at SDOs. But at the same time, cautioned against bringing antitrust into what would be considered to be a contract dispute where there's no evidence, no factual basis for finding any exclusionary practice. And the key to a single firm conduct abuse would be the finding of exclusionary practice. I think that we're on the right track. I think, as I stated before, I think the issue is one of continuation. No radical change has really occurred from administration to administration in the areas that Bill was talking about: mergers, single firm conduct. And I think it's headed in the right direction. I do want to pick up on one of Bill's favorite topics, and that is the need for retroactive analysis of whether an action or inaction by the government has produced the result that is consistent with consumer welfare and continuation preservations of innovation. I think that more work needs to be done in that area, and one needs to find a way to eliminate the externalities and come up with reports and analyses that do give a retroactive report card, if you will, as to how the airplane landed, to use a Bill metaphor, and not how it took off. So thanks very much.
Yeah, thank you, Jim. Thanks for getting us off to a great start. To think back to Mike's time as chair of the FTC, I think in some ways Mike doesn't get nearly enough credit for some of the institution building things he had in mind, and the development of the FTC's ex post evaluation program really goes back to Mike. The review of vertical restraints decisions, the review of the Xerox settlement in 1975, the single firm behavior program. That's a program Mike put in place. I don't know if Mike anticipated quite the answers that would come from all of the studies, but if we look at the origins of the development of the FTC's modern program in that era, that's a Mike Perchuk innovation. Jeff.
Thanks, Bill. Well, let me talk first on the question that you've raised. Was it all that dismal? And I think one thing you can say with a great deal of confidence is to the extent antitrust enforcement policy has been dismal, it's been consistently dismal for quite a while, as Jim was alluding to, with improvements all along the way, but with, I think, it being very difficult to say that has been much of a dramatic change between a Republican-Democrat administration, whatever the case may be. I think there's been a tremendous amount of consistency, and if you look at the statistics on number of transactions, number of second requests, there are little blips here and there over the past 25, 30 years. But on balance, I think, both as an enforcer on the inside, but also as a practitioner on the outside, the rhetoric may be a little different between different administrations, but I think the enforcement policies were very consistent. I wanted to touch on just a couple of points in the opening remarks. One of the things that frequently was asked of me when I was bureau director was to talk about the way the FTC applied the various goals of the antitrust laws, and in particular to try to drill down a little bit into how we looked at total or allocative efficiency versus consumer welfare, those varying goals that sometimes are thrown out there. And in all honesty, I remember being asked that question in particular at a class I was teaching. My daughter was at UVA Law School. I'm sorry to say I'm that old. And the question came up, how much do you take into account allocative efficiency versus being focused on consumer welfare? And my honest response was, well, I think I might be able to draw the chart, the little graph up on the board if you told me that I needed to do it. And I might be able to tell you which box is supposed to be the deadweight loss and which are the other boxes on there. But as a practical matter, as far as enforcement, certainly on the merger side at the FTC, it never came up because there was never an instance, at least during the time I was there, where the commission would conclude that there was harm to consumers, but nevertheless the efficiency benefits outweighed the consumer harm. It just didn't work that way. And that was not only certainly what I've seen on the inside, but on the outside as a practitioner, we make efficiency arguments, and it's not that those are completely disregarded, but certainly they're really given relatively little weight. So the argument that somehow or another there's way too much emphasis on efficiency considerations, on allocative efficiency, and the like, I think is just misunderstands how enforcement really works at the agencies. And the reason for that is I think fairly practical. There's too much work down at the agencies, and there's too much of a flow for the agencies to spend all of their time sitting back and thinking about some of these really high-level goal-type policies. There's some effort there, but the day-to-day work is trying to figure out how to look at an HSR filing, for example, within the initial waiting period and do the job of getting an initial read of that without having to issue a second request or figuring out whether a second request is necessary, but getting the job done. And I'm really struck by something Bill wrote, an article Bill wrote a couple of years ago, talking about the focus of paying too much attention to distinctions between the goals of antitrust. It makes it very easy to miss what may well be more important, which is the design of the agencies and how you have it set up, where, for example, at the FTC, most of the staff on the Bureau of Competition side is looking at mergers. And they are set up in a situation where they don't have authority under the Hart-Scott-Rodino Act to simply say, we need a little bit more time, so negotiate some more time. It's either let it go, issue the second request, and I grant you more and more today, it's pull and refile, but there's no statutory authority for the FTC staff to just negotiate some additional amount of time. So the flow is constant, and there are a lot of transactions. There are 50 plus or so second requests every year at each of the agencies, and that requires the staff to be pretty much fully occupied looking at those mergers. Now, there are a couple of groups that do look at anti-competitive conduct or non-merger conduct, but they too have tended to be very busy with the healthcare shop, for example, being very busy with their pay for delay program, and the anti-competitive practices shop doing what it can with really fairly meager resources and trying to figure out if there's something positive that they can contribute. One of the things that they frequently, the anti-competitive practices group at the FTC tried to do was come up with some rational boundaries, some rational policies on how far to extend Section 5 of the FTC Act, which can, on the one hand, appear to be completely unlimited or uncabined. On the other hand, when that happens, as Bill said, there are all kinds of negative consequences that come from outside the FTC. So you see anti-competitive practices cases like Vlasic, where the commission did decide that there was, in an invitation to collude context, a legitimate reason to go beyond the parameters of the Sherman Act and say, even though that's not a traditional antitrust violation, we're going to conclude that it's a Section 5 FTC Act violation. Likewise, again, especially at the FTC, you have to take into account that there's always only 3 members of the majority political party, frequently 2 of the other, or at least there's only a majority of one political party. And that means there's more diversity of view, more diversity of antitrust policy perspective than frequently would be the case if you didn't have that kind of mix of political parties. And that was something that we saw very commonly, and given the collegial nature, at least at the FTC, that diversity resulted in lots of actions that probably wouldn't have been taking place if it was just a single political party setup. Again, I pointed out because it's the design of the agency that largely, I think, leads to these kind of results. And the idea that it's some kind of high, what I don't know how else to say other than highfalutin antitrust goal involving something that's a fairly complicated to understand economic theory is just not the way the practical daily reality works, I think, at the FTC. If you want more, you really, I think, have to change the design. The last thing I would just say is, and again, this is somewhat stealing from Bill's good work, that the agency lawyers, certainly at the FTC, but the leadership as well, they are really keenly interested in their professional reputations and making sure that they are making decisions, being viewed as making decisions on the merits. And along with that, it is the fact that I at least am unfamiliar for the last probably 25 years at least of any leadership at the FTC that comes in and tries to adopt a Calvin Coolidge type commitment to inactivity. Nobody ever comes in and says, my legacy is going to be our inactivity. And instead, everyone, whether they're the most conservative or the most liberal, wants to be come out of that experience with a legacy of being able to say that they did something that was positive, that was helpful for consumers. And I think that's one of the great consistencies of the past 25, 30 years at the FTC, is that that's the way both the leadership and the staff have really approached their work.
Thanks, Jeff. It's interesting to look at the statuary of Washington, D.C. and the squares and circles that feature so many Civil War luminaries, with a couple of exceptions. They all got their place on the plinth because they did things. When you go to Farragut Square, there's not a plaque that said, "Oh dear, torpedoes, run away." When you look throughout the, whether it's McPherson, Thomas, Logan, circle after circle, these are all people who use their authority in a forceful way. And I suspect to look at the mind of the typical enforcement agency senior official, but also of the case handlers, they do not imagine themselves establishing a legacy that said, "I did nothing." Though whether their attitude should be encouraged, whether more ambition is appropriate, is in many ways the heart of the current debate. Aviv.
Thank you. So I'm here as an economist. I think I'm the only economist on either of the panels.
We are all economists now.
Okay.
We're all lawyers.
Y'all like to think you're economists.
Yes. Don't shatter our illusions, please. Thank you.
I'll try. So to answer the question really put in front of us, let me kind of approach it as an economist, and especially the type of economics that I like to do, which is empirical economics. So in my view, one regression, or one good regression, I should say, one good regression is worth 1,000 bad theories, probably even a little bit more than that. So let me make a couple of observations to try to kind of, in some sense, see both sides of the story. And I think it is important to see both. So on one hand, if we look over the last 30, 40, even longer horizon, GDP has been rising, right? We're at the kind of at this era, kind of unprecedented era of economic growth, right? And this has mostly been driven by innovation. So you could step back and say, look, yeah, correlation is not causation, but, it looks like policy, competition policy, maybe can't take all the credit, but at least didn't screw things up. Okay? At least we didn't sort of stop this progress. And it is important to realize that even with the best intentions, a lot of time the best you can do is to do no harm. And we have to be sort of careful thinking of kind of this long term of growth and saying, yeah, could have we tweaked the engine a little bit to make it run a little bit faster? Yeah, but at the same time, we could have actually also slowed it down and really kind of broken down the car. Okay, so that's kind of one big picture that I think we have to keep in mind. So that's on one hand. On the other hand, there's a lot of claims that concentration has gone up throughout this period, a lot of anti-competitive behavior. Some of it is based on empirical work, and let me go back to the emphasis on kind of good regression that I made earlier. Some of this work here, I would not classify as good work. I would have a hard time presenting it to my students, or when I present it to my students, I give it as an assignment of explaining what's wrong with it. So there is some work out there. To me, the one thing that's somewhat troubling and a red flag is when you look not at increased concentration, not in various other measures that people have put down as here's a failure of competition policy, but is decreased entry rate. So that's the one number that to me raises a red flag. Not higher profits, not higher concentration. Those are things that are okay as long as the competitive process continues to work and there's dynamic entry and dynamic innovation trying to kind of work against this. That's the one number that, and I keep telling my students, if I'm going to send you to sort of study something, it would be that. Understand, is that a real fact? And if it is, what's driving it? So that's one issue and one kind of aspect of, if you want, the other side. Yes, we've had this growth, but let's look at the other aspect. The other issue is that even though there's been growth, GDP per capita is great, innovation is great, inequality has been increasing as well. And we'd like to walk away from it and say it's not our problem, but it is. Okay, and if we learned anything from the recent election is that that's what's keeping people up at night. That's what's kind of driving people's behavior. Maybe not, not people around us. We've all been very fortunate, been doing well, but that is something that we need to think about. Now, does that mean that antitrust is a solution to it? No. Why is it even brought up as a solution? I think partly because we're the one part of kind of government and, if you want, regulation and law enforcement broadly defined that people think, hey, it's working well. So why don't we apply it also to other stuff that maybe traditionally is not under the antitrust realm? And there's a lot of talk about, dropping the consumer surplus or kind of increasing it and adding other parts to it. In my view, it depends a little bit what we mean by that. If the view is to say we shouldn't just be focused on consumer surplus in a very narrow sense of just price effect and just on downstream consumers, yes, maybe we should actually be looking at not just price effect, but also what happens to quality, what happens to other things. But my claim is I think that's what the agencies have been doing for a while anyway. Should we not just look at downstream consumers, but maybe also think of what some people like to refer to as trading partners? Okay, so whether it's downstream or whether you're affecting your suppliers, if you want to look at monopsony behavior, okay, that I think is again kind of maybe a reasonable concept of saying it's consumer surplus, consumer welfare, but let's kind of redefine a little bit what we mean by welfare and what are the effects that we're looking at. But if we're going to start throwing other stuff in there, okay, like for example, there's been claims that we should start looking at inequality as a measure to be thrown in, not just what happens to overall consumer surplus. I think that's a very dangerous precedent and one that we should actually be very careful about.
Thank you, Aviv. Bill.
Thanks, Bill. I should disclose that I kind of bookend this conversation because I was on Mike Perchuk's staff in 1977 when he gave those two speeches that Bill Kovacic cited at his opening. But let me address the title here. Was it all that bad? I think that's a terrific title for the few hours we're going to be spending together here. It reflects, I think, a widespread view, one that I personally share, that antitrust enforcement today is more predictable, it's less partisan, as Jeff and others have said. It's better grounded in industrial organization economics. It is more committed, as Jim Rill, with his iteration of the merger guidelines, developed in making sure we tell a story of competitive harm, not just from transactions, from behavior before we act. And antitrust these days, I think, is government enforcement is more successful in the courts than ever before. I think this panel and next, you'll see we're kind of all got ground zero on that shared view. But as I thought about this some more, and it's maybe I'm getting older and crankier, although Renata's here and she would say you're always cranky. But are we a little bit too self-congratulatory in what we've done and how we've done it? Do we need to be a little more self-critical? You could have named this program, what have we missed? What needs to be done better? Because as Aviv said, there is some evidence out there suggesting that our economy may not be functioning as competitively as it could, and we ought to be asking the question whether there's more that can appropriately be done on the antitrust front to address it. You talked a little bit about what's going on with entry, dynamic efficiency. There are some data out there cited recently by Carl Shapiro in a paper that concentration may be increasing. There's a little bit of dispute about that evidence. But Carl also talked about the fact that corporate profits as a share of GDP over the last 30 years has increased from 7-8% to 11-12%. What's going on there? Are efficiencies that maybe come about from increases in size actually generating rents that go to shareholders and not actually producing a more competitive environment? I think we ought to be asking those questions. And another related question Aviv touched on, as we get caught up in terms. We talk about consumer welfare. Should that be our touchstone, or does it need to be more? Well, it kind of all depends on how you define consumer welfare, right? I think if you talk to some people, they see consumer welfare as exclusively focusing on short-term price effects. And if that's all we're looking at, we may be missing some things going on, including issues relating to bargaining leverage, issues relating to market distortions. We may be not sufficiently, even though we think we are, paying attention to innovation, to transactions that increase barriers to entry. You know, as we look at this new economy, are we appropriately assessing the success of social media and other two-sided platforms in the right way? So, and should we, you know, should we look more critically at things we've done? Everybody talks about it, but we may not put enough resources into it. I had a tough call to make with Aviv and others about whether to allow the third in the big series of airline mergers, American Airlines, US Air. We made the judgment at the time that settling that with certain divestitures of routes, of slots, had a chance to shake up the market in a way that a simple injunction would not, that we would have been preserving, if we had blocked that deal, a fairly oligopolistic status quo. So, you know, do you try and come up with a settlement that changes that? We made that judgment in good faith, and I think we were convinced then and are convinced now it was the right thing. The empirical data aren't there to decisively conclude one way or the other. It would be good to know that. I think back to the 90s and the cruise ships decision out of the FTC. You read what Tamiris, Mary Coleman, and others wrote about the rationale for that decision at the time. It was a thoughtful analysis, not super detailed, but thoughtful analysis of a decision not to challenge. Has that proven out to be right? I don't think there's any good data out there that helps us understand whether, particularly decisions not to enforce, get us to the right place. So I'll flip it back to Bill, but the basic premise of my opening remarks is I think we need to be self-critical. I am not arguing in favor of a fundamental change in the way we look at antitrust. I do think there's a risk of trying to stretch it to do things it cannot do. At the same time, I think we can be more sharply self-critical than maybe we've had a tendency to be.
Thanks, Bill. That's great. And I should mention to the group, I think that you know these folks and you understand the careers they brought to the field, but just to cover a bit more of the range of experience that's packed into their observations. Bill worked both during the Mike Perchuk era, as I did. That was my first job after a clerkship, where I remember Mike's welcoming letter, welcome me to the world's greatest public interest law firm, going to the FTC. Bill also worked with Bob Potofsky during the Clinton administration as the head of Bureau of Competition, and most recently during the Obama administration as the head of the antitrust division. So Bill's experience among all of us here is really distinctive, having spanned both in time but in responsibility a remarkable period of activity. Aviv served during the Obama administration with Bill at the Department of Justice. Jeff, I think 2 times at the FTC, once during the Reagan administration working with Jerry Calvani, and then during the second Bush administration working as the head of the Bureau of Competition. And Jim, head of the antitrust division during the first Bush administration. But Jim, of course, a student of the process, really from a long period during the post-World War II period, everything from a young associate in a law firm up through the head of Blue Ribbon Commission. So as well as his time in the division. So we have an extraordinary perspective here of how the system has developed over time. I'd like to come back to one specific thing I might ask each of you, and Bill's touched on this in some ways. All of our panelists have, but I guess to put the question this way, any regrets from decisions? And if not necessarily regrets, doubts. Areas that are worthy of a further detailed look. Because one suggestion in the modern critique is, as all of our panelists have touched upon, more resources to go back and look at how things turned out. So if I can ask you, maybe the harder version of the question is regrets? Of course, I have none, but you might. Or much more mildly, doubts as you think about the critique. Doubts about how things went, where you would like to go back and take your prior assumptions at the time decisions were made in good faith with the information you had. Doubts about whether or not the priors match up well with what actually happened and what we might learn from that. If I could start with Jim, and go down the table. Doubts or regrets?
Frank Sinatra, regrets, I have a few.
Regrets, I have a few.
I mentioned airlines, and frankly, you know, understanding whether we came out in the right place on that as in a series of administrations, because there were a series of transactions which concentrated the market. To get a little more granular on that, you know, there have been some studies, Dennis Carlton, Mark Israel, about there appear to be recently no evidence of short-term price effects on head-to-head competition. But what has happened by the reduction in the number of independent hubs? You know, have we had a quality deterioration? You know, understanding that sort of thing a little better. I would, were I to go back in, and I don't think that's happening, trying to think, okay, here's the first mover in what is likely to be a series of transactions in an industry. And do we need to take a hard look where the first mover is somebody really big acquiring somebody small and potentially innovative? Would it be better off in terms of the competitive functioning of that market if we went hard at the really big one gobbling up some of the smaller innovators and letting those smaller innovators get together with other smaller firms? It's a question I'd like to ask. A related question is potential competition, and it may be judicially that that, you know, we're very limited in what we can do to proceed on a potential competition theory. Debbie Feinstein's not here yet. I think she'll probably talk about that in panel 2. But have we thought through innovation? Have we thought through what happens when big successful platforms move into adjacent markets? Is that having an effect on competition that we're underappreciating, discouraging entry and expanding the success of the successful platform? So those are issues that I'd like to be thinking more and more about, and think antitrust enforcers need to continue to think about.
Thanks, Bill. Aviv, doubts, regrets.
So maybe it's not going to be surprising that as I was thinking of how to answer your question, I had two things in mind: a song that Bill already took from me, and a case that Bill already talked about. So I just want to say, you know, what he said.
In many programs, the order is very important, because people will take all the cheap jokes first.
And the cheap cases, maybe, I don't know. But I'd like to say what he said. But let me just add a little bit about airlines, because that is a case, you know, that I have. I gave actually a talk at Yale about a year ago, you know, academic paper. But they have this tradition that you come and you give a seminar, you spend the seminar, kind of the lunch, with kind of all the IO economists talking about stuff. I was kind of running late. I was preparing to testify in a big case you might have heard of a few months later. So I was kind of cutting it late, literally got off the train, straight into lunch, grabbed my little thing, they had tortillas, you know, grab my tortillas, sit down. Before my butt hits the chair, I'm asked, so what do you think about airlines? Okay, how come you guys got it wrong? Okay, and just kind of, you know, getting drilled on. And that's kind of a very common, like, you know, what were you guys sort of, were you guys thinking? And that is sort of a question that I think I've had to answer multiple times. And I think, you know, as Bill said, you know, we made, I think, the right decision, given the information we have. I have, however, wondered as an academic, you know, what has happened? So the data actually for US Air, American is just coming out. We'll have to wait probably a year or two before we can actually look at. But I have actually looked at what happened at United Continental, going back. I mean, you talked about the need for retrospective. So we've actually been working on that. And it ends up, it's not very easy to answer. So if you look, I know, Dennis and Mark Israel, Dennis Carlton, Mark Israel have a paper claiming certain things about price effect. We actually see something a little bit different. We actually did see that there was actually a price effect in markets where there was larger increase in concentration. But that's not the end of the story. So prices did go up. On the other hand, so did overall quantity. Okay, and again, we can talk about how we sort of measure it, but the idea is you say, if consumers are so much worse off because of higher prices, why were they flying more? Okay? How do you reconcile these two things? Okay? So what Dennis would say if he was here, say, well, there was an improvement in quality, right? You had a better network, yes, you were paying more, but the quality adjusted price was higher. Well, it ends up it's not quite that simple, because if you look at the share of the merged firm, United Continental in that case, it actually went down. So if it was so much better than everyone else because they had a much better network, why was it losing market share? Why were others gaining? Okay, so the question is, how do you put those three things together? Okay, the kind of the three facts, and it's not easy. Okay, we're working on. So the point is to say, it's not even as simple, even ex post, to kind of say, was this good or bad to consumers? The answer might be was good for some, bad for others, and then it goes back to a little bit of kind of what weights do you want to put on the different consumers? Do you want to look at the average consumer? Do you want to look at overall? It's not as easy. I think that's kind of the point that goes to that. So that's one point. The other point, again, building a little bit on what Bill was saying, and it's something that, when you started when I was at the division, is really starting to think about bargaining power and kind of bargaining leverage and the effect that that has. So let me give you actually an example. I'll kind of move it overseas, so it's actually much easier to talk about. The Israeli Antitrust Authority right now is really struggling with the fact that they have a few very large food conglomerate in the country. And what happens is you have someone, let's say, is big in the pasta category. Okay, they have 50% market share in the pasta category, and somebody says, we're going to buy a small manufacturer of, let's say, breakfast cereal. Okay, and what we're going to do is we're going to have efficiency because we're going to help bring these guys into all the supermarkets because they can't do that on their own. On the other hand, the supermarkets are claiming, but now they have much more bargaining power towards us, right? So how should we think about stuff like that? Right? So traditionally you sort of say, look, this is a different category. How are you going to use it? But when you actually hear market participants, they have a concern. How do you put that together? That's, I think, I don't know if it's much as a regret, but it's something that I think we've started, and I'm hoping will continue along these lines.
Now, if I can pose another question to Aviv in particular, there have been some interesting, very thoughtful and reflective pieces on what the data say. Carl Shapiro's paper on antitrust populism, which is available on SSRN, has an extended discussion of what the much-cited reports from the Council of Economic Advisors, from other commentators, have to say. And he goes through in a very careful way what the significance of this is. But it seems to me that something that is missing in the current debate is that those views aren't joined up very well with the critique. There seems to be a pervasive and almost automatic assumption that specific industries that you've seen mentioned in accounts that are raised again and again, airlines, failure, area after area of policy. Is there something wrong in the way in which the debate's taking place here? Is there a path by which these different views, including your nuanced observations about what we might be seeing in this process, is this discussion going to be joined up in a meaningful way, or is this going to take place on two entirely different paths?
So I don't know the answer to your question. I do know that looking at some of these so-called empirical facts, I mean, the facts are there. The question is how you interpret them, and it's a broad stroke. There's a lot of papers out there. So without specifically talking about Carl's work, I know some work that's been done that's saying people saying the concentration of the top 50 firms in a sector has gone up. Okay, my view, if there's 50 firms in a sector, an industry, it's a competitive industry. Okay, and
it's not bad. It's okay.
Okay,
I think.
So I think that's so concentration. Let's say 50 has gone up. Okay, I can live with that. That's not the margin that we're talking about. People talk about firm profits have gone up, or the share of profits out of total total revenue. Again, that in itself is not a bad fact. I mean, this goes back to kind of the old kind of Chicago school critique of the structure, conduct, performance paradigm type analysis. That, profits going up is not necessarily a bad fact. It could be just return on innovative activity. And indeed, some of the more detailed studies that look at it say, where are these coming up? Where are these profits? It's exactly those kind of, the largest, one study actually found that the largest return is like medical devices. Okay, you have a new medical device, there's a lot, big fixed fee, and then if you succeed, yes, you're going to clean out for a couple of years until someone else enters, right? And that's how the dynamics of competition work, right? So this goes back to the point I made in my earlier comments, which is the thing that's troubling to me is if we do not see that entry. And the question is why? Are there barriers to entry that prevent the next medical device coming in after we see the initial one? The fact that the initial innovator makes a big return, that's fine. That's exactly how we want competition to work. That's how innovation works. The question is, can they somehow prevent the entry from the second, third, and fourth guy? And if that's happening, that's a concern. Okay, so that's the one, if I look at these statistics when they have information about declining entry rates, that's the one red flag. To me, it's not the high profits, it's not the concentration at the C50, the increased concentration. Is there a decrease in kind of the entry and the response to these high returns?
No, thanks. Jeff, if I can turn to you. Doubts? Regrets? I could even introduce another classification called hesitation. That is that moment of uncertainty that occurs when you hear an argument that puts you on the back foot for even a second.
Well, the regret that I was going to talk about is really a process regret, getting back a little bit to the agency design. And that is by nature of the Hart-Scott-Rodino process, the agency has the filing, has 30 days to decide whether to issue the second request. And then at that point, there's a great deal of uncertainty between the staff and the outside parties as to where the investigation is going to go there. Most parties say, of course, that they're going to fight it until the day is done, but the practical reality is most of these matters are settled. From my perch as the director, one of the things that I had to balance was the need to be fully prepared in the event that the parties did want to proceed with a transaction that the commission thought should be challenged versus the budgetary restraints that we were operating under that permitted us or would enable us to become fully up to speed and fully capable of litigating. And where that rubber really hit the road was on the decision of when to bring in an outside economist, because rarely would we at the FTC go into court with the staff member of the Bureau of Economics as a testifying expert. Instead, we would go in with an outside expert. Up to some point during the investigation, however, the economic analysis was handled totally by a member of the Bureau of Economics. When that switchover would occur, turned out, I think, in at least some instances that I can think of, to be really problematic, and particularly problematic in the sense of, in a couple of instances that I can think of, where the Bureau of Economics came to conclusions that when we did end up hiring the outside expert to prepare for litigation, then the outside expert did not confirm, did not agree with. And that put us in a very difficult position, again, process-wise, because sometimes that decision to hire the outside economist may have been made before the commission voted to seek a preliminary injunction, for example, but the conclusions of the outside economist may have come in after that point in time. And what to do in that kind of situation, I've always thought was a real challenge, and one of those areas where bluntly, I wish it just didn't happen that way. But we, as a practical matter, again, could not afford to go outside and hire an economist. For example, once there was a response to the second request, or once there was a second request issued. We had to be much more sure that we really needed to spend that money before we were able to pull the trigger on that.
To give us a benchmark on Jeff, without mentioning a particular case or a particular person, how much does this cost if you go the distance with the outside advisor coming in?
Well, I mean, this was several years ago, but at that point in time, with discounts that we would be able to negotiate, we were still in the $1 million range for the economist.
And I'd like to come back later to your thoughts more generally about, with all of the kinds of additional work we'd like done, do we have to think about the way in which the agencies behave and the way in which they perform and operate? That is, for the kind of adjustments we have in mind, but maybe to come back to agencies in a bit more. Jim.
Thanks, Bill. And if you got quite a while, I can go through all the mistakes I've made and regret. It'll take too long, and I don't want to trench on the next panel. I do
just
want
top 5 would be great.
I'll rattle off a few, but let me just make a quick comment on Bill Baer's comments, which I thought were very trenchant. And I agree that we need to keep asking ourselves, are we doing the right thing? But Bill, I would suggest we are. I think that process is going forward too, and I think the various iterations of the horizontal merger guidelines and the different questions we're asking as those proceeded through the continuity shows we're asking the right questions. Asking the right questions about the impact of concentration on R&D and innovation. When Tim Uris was head of the FTC, there was a considerable study done on exactly that, and more questions to be asked, but one finding of that was don't leap to conclusions about the adverse relationship between concentration and innovation. So we are working on it. I agree with you completely, but I think we are. Are we doing enough? Probably not. But the process goes on. Regrets. I think one major regret I have is that we were not able to do more in the area of deregulation. That we're not able to have our views, the views of competition, infused and adopted by some of the sectoral agencies. I remember putting somebody up to testify on a milk marketing order, for goodness sakes, and the Agriculture Department Administrative Law Judge refused to let him testify because he said he wasn't a person. Well, I know him pretty well. He was a person. I was appointed by the president to help in his deregulation efforts in 1992 to, remember his State of the Union speech was going into deregulation, and they ran out of people at the White House. They said, well, you handle transportation. I ran into a buzzsaw at the Transportation Department who had no interest in any kind of making the market wider open on slots, for example, for getting rid of the IATA total exemption, for example. No interest in that at all. I think the idea of deregulation was let's not let drunks be pilots in airplanes. Well, it's a good step, but not quite far enough. So I regret that I think that we, in the ICEPAC, the International Competition Policy Advisory Committee report, we suggested that competition issues, antitrust type issues, should be predominantly the jurisdiction, the focus, the role of the antitrust agencies, and that the sectoral agencies should take a pass on those issues to the antitrust agencies. That was not an issue that was picked up on. Actually, the fact is that the chairman of the Federal Trade Commission, then Mike Powell, said he agreed with me in a public statement. But we didn't, there's still much progress to be made, I think, both here and abroad, in attempting to have the antitrust ethic, if you will, resolved principally by the antitrust agencies and have more influence than it has historically with the sectoral agencies. I have other regrets. Probably we could have done more in the way of developing better guidelines for vertical mergers. We could have done a little bit better, I think, in outlining some of the unilateral effects part of the merger guidelines and repositioning But I think the major regret I have is the one where it focuses on, frankly, the role of antitrust to play in sectoral regulation and attempting to knock down some of the anti-competitive barriers that are put up by frankly, by the sectoral agencies.
I'd like to come back to for a second to the question of inequality. This is a pillar of the modern critique, which is that income disparities have increased, that we saw partly in a reaction to the crisis in 2008. We've seen a greater social perception, among other things, that the system fails the dispossessed, that it fails people in the second half of the income distribution, that there was a failure in 2008 of the relevant financial services firms, of the regulatory process, and that it has rendered markets and government oversight, in some sense, as less legitimate than they were seen to be before, all to the disadvantage of people who have less rather than more. It seems to me that this is a persistent concern in the critique. I doubt that Bernie Sanders would have gotten the attention he did in the campaign were it otherwise. I seriously doubt that Donald Trump would have become the president of the United States had he not tapped this vein of concern. It's a deep, fundamental concern about the way our economy functions and the relevant institutions. And a key part of the critique, as several of you have mentioned, is that antitrust failed here. That is, it did not do its job in arresting commercial developments that have contributed to imbalances in the political process, imbalances in the economy that make things work against the well-being of citizens who have less and citizens who are vulnerable. Is there more that competition policy should do to address this? If only to draw attention to areas in which, at least as a byproduct of what it does now, it has the effect of ameliorating some of these conditions. How does competition policy and its chief officials engage with this debate? And is there a risk that if the answer is, it's not our job, that is, we're not necessarily good at it, that we just fall to the margins and become less important? How do we engage in this discussion?
Well, I'll start. You know, I thought you framed the question fairly and well, Bill. You know, there is a critique out there that takes the underlying concerns you identified and places a lot of the blame on under-enforcement of the antitrust laws. You know, I'm not sure I would go anywhere near that far, although I began this thing suggesting we ought to be self-critical. I do think you look at areas where we could do more. Looking upstream at coordinated efforts at wage suppression, whether it's hospitals in Michigan getting together to try and put a cap on nurses' wages, on the whole do not poach thing. You look at areas where I think one of Macon's deputy mentioned a month or so ago that when he got to the department, he was surprised at how many investigations are looking at behavior involving HR departments and the people to whom they report. I mean, that's an area where if there is collusive conduct going on, we ought to be going at it aggressively. And I do think antitrust enforcers have tended to look more downstream and a little less upstream. So I think there's that. Aviv has talked about, you know, if in fact we're not seeing entry. You talked about medical devices. I am a great consumer of medical devices. If you ever see me go through a metal detector, you'll know that. You know, but do we have? Is there something systematic going on that is allowing innovators to gain more than the legitimate monopoly rent their invention entitles them too. So I do think there are areas where looking to promote a more competitive economy, looking to address imbalances of power which result in wage suppression and related type efforts, those are legitimate areas for antitrust to think, look at.
Bill, I quite agree with those areas that you're talking about. It seems to me that those are legitimate areas of antitrust, but I think that the drumbeat out there goes broader than that, and it's asking for antitrust to take a broader role in solving overall problems of inequality. And I think that probably is not the role for antitrust. I think the types of things you're talking about, whether it's cases of collusion to suppress wages or to have no poaching agreements, those are traditional antitrust concepts being brought into play. To seek for equality, equal treatment for its own sake, I think goes beyond the appropriate role of antitrust, and not only damages antitrust, but raises, I think, overall questions as to the type of economy and type of system that we want across the board, and not one that can be properly addressed in the big by antitrust.
Yeah,
Jeff,
can I just underscore that? I think that I agree with Jim that most of what you've said, Bill, I think you can legitimately say more should be done there, but it's certainly within the mainstream of what I think the agencies would consider legitimate. It seems to me that what we at least ran into when I was at the FTC is there would be a number of constituencies that would come in, whether it's the local congressman, the governor, some state representative, coming in and arguing that we should, for example, object to the transaction because it was going to impact labor. There were going to be firings at a local plant, or there could be some environmental problems resulting from the transaction, and it wasn't that. Those of us at the FTC, and I'm sure at the division, weren't sympathetic to those arguments, but we didn't have any standards to use to apply that kind of analysis. So, it's not as though anyone at the FTC certainly was looking and saying, we don't care about inequality. It was, I think, much more of, we don't have any legitimate way to apply a standard that we can hold ourselves out to being objective decision makers here, rather than just basically closing our eyes and throwing the proverbial dart at the dartboard and saying, what the heck, well, at least we're doing something. And I think it gets back to that point about from the staff, the leadership at the agencies are very concerned, and I think legitimately so, about being able to hold themselves out to applying objective standards. And when we get outside of competition law, I think it becomes very, very difficult to figure out what those objective standards are. And sometimes even when it maybe touches on competition law, it still is difficult. And an example of that I certainly came up a lot during the time I was at the FTC was with the Hurricane Katrina and Rita, and the price gouge, the quote unquote price gouging that went on there, and efforts by Congress to force the
petroleum
FTC,
products. Yeah.
Right, to enforce price gouging regulations that typically didn't exist, but to prevent price gouging, and we tried very hard to figure out what's some kind of objective standard that we can apply, and I still haven't seen one.
Well, Jeff, you may remember, and I have painful memories of this, how the FTC in particular, with its Section 5 mandate, dealing with unfair methods of competition or unfair deceptive acts or practices, a repeated admonition by legislators was, we've given you this deliberately elastic mechanism. Why can't you come up with some approach that deals with what Europeans might call excessive pricing in these specific situations? Why can't you do something about that? The power is there. You're telling us it's hard to do, but We gave you a difficult job, we acknowledge that, and you're not doing anything. You're not taking any steps to use this authority. And you might add, that authority still exists now, Federal Trade Commission. Why aren't you taking this deliberately elastic mandate to get to work on this kind of problem? That was a continuing refrain. And if the legislator continues to focus on this, what's the agency's answer today to demands that it engage more broadly in this area? If you're testifying on behalf of the FTC, what do you say, Jeff, today to the legislative committee that says, it's hard, but we gave you that job and you're not doing it? What does one say today?
I think I would probably say today what I remember saying at the time, which was, we will investigate all and take all appropriate action against price gouging that we find violates the antitrust laws, which was, which was not what, which didn't get us very far, because in the price gouging context, it wasn't normally part of some kind of collusive activity. It was the single really incredibly unethical person who was frequently just gouging somebody by selling them tripling the price of the electric generator or whatever it was during the hurricanes. But there wasn't really much more we could say, but that is what we said at the time.
Aviv, do you see other things we can say about the inequality critique as it's brought in a broad or narrow way?
So I'm not sure I know what the answer is, but I know what it's not. So it's not, I think, one of either extreme, right? One is to say that antitrust is the answer to everything. Okay, so everything that's wrong in our economy, antitrust is the solution. That's not going to, and I say everything, of course, I'm exaggerating, but inequality, a lot of other things say antitrust is the solution, everything. And again, it goes back to, in my view, the reason we're lashing antitrust, because it works. It actually can look and say, look, they're doing a good job here. Why not also have them fix this problem over here? Okay, so that's, I think, and that's kind of the view, I think, especially this side of the table, and I agree with that. On the other hand, I also agree, I think, with what Bill said, that the solution can't be that, look, we're doing everything, there's nothing more that we can do. Okay, so that's the other extreme, that I'd say antitrust is the answer to nothing. Again, nothing beyond what we already are doing.
Yeah.
That's probably not the answer either. We should be looking harder for things in which we can improve, things that we could be doing. And we're talking now about the whole last 30 years is kind of one continuing. But think about 5 years ago, if we would have sat here and I would have told you that either the FTC or the DOJ would have actually litigated the scale of cases that they did just about a year ago, right? 3 hospital mergers simultaneously, okay? 2 of the largest healthcare mergers at the same time. You would have laughed. So the agencies don't have the capacity to do that, okay? Yet they did, okay? And that's kind of a direction that I think if we had this 5, 6, 7 years, I don't know exactly when, you would think, we're doing everything we can. Well, we kind of pushed and things kind of went further. Okay, so there is kind of progress, and we can, we should continue to check and test and make sure that there maybe is more that we can do.
My impression is, Aviv, that the agencies get exactly no credit for that. That is, in the current critique, that's a nice start. That's a warm-up. That's a preliminary to doing the job that you really should be doing or should have been doing before. I think our perception is that was ambitious, and there was nothing easy about doing that. Jeff and I remember how hard it was to recover the hospital merger program, which was extraordinarily difficult. Both of you know firsthand how hard it was to run the cases that you did. But my sense is the credit given for that is not robust. The sense is that you really should have been doing a better job. Indeed, that shows that what you could have done if you really had an ambitious program. How does one make clear how hard that was to do and what's involved in doing more of it if you want to? is it possible to gain acceptance for the idea, on the lines of, was it all that bad, that this was actually a genuine accomplishment and worth respecting when you think about the institutional capacity that you have to build, sustain, and expand to do this? Is that missing? Have we failed to make that clear?
I would say bring the critics in for a week at the FTC, the DOJ, try to go through one of these. Have someone in and come say, you know, you're gonna get deposed on this particular matter. Let's see how easy it is at that. I mean, I think it's easy to talk from the outside. Oh, it's very easy to bring some of these, but you have to see sort of the analytics and the process that you have to go through to prove the, the hundreds, thousands of hours that go into each one of these cases. Okay, day and night. I think that at that point it would be much clearer.
Well, that is one reason, Bill, for example, why when we were doing the petroleum investigations after the hurricanes, there were, if not weekly, probably every couple of week briefings of congressional staff to make sure they understood the level of effort that was being put into that. I think we knew what the outcome was going to be, but it was very important that they understood how the process had worked and that there was a very, very strong effort to come to the right conclusion.
Though I recall, and I suspect you do too, Jeff, that, and it's relevant to today's debate, that when you said, we've looked at it from every direction, there's not an easy solution to it. That was completely unconvincing. That was taken as evidence of inherent timidity, lack of courage, lack of imagination, and was seen as a basis for failure. I remember Mike Salinger, when he was the head of the Bureau of Economics, sitting before one committee, and they went through a list of things. Why don't we cap prices? Why don't we establish a government-owned benchmark where we could test what prices were in the market? And to each of these, Mike said, no, no, no. To quote the late Amy Winehouse, no, no, no. And the chair of the committee turned to Mike and said, well, Dr. Salinger, what can we do to affect the prices? And Mike said, if you want to move the price, you can either make more or use less. That completely wrong-footed the committee, and the next words were, thank you, Dr. Salinger. I didn't quite know how to respond to that. But I recall how painfully inadequate all of our answers seem to be to those questions. And I don't know if they will be more persuasive now. That is, do the agencies have the sense of, do they have the perceived legitimacy in the face of the critique to make the arguments effectively to these audiences? Bill, Jim?
It seems to me the answer can't be just no, no, no. It has to be, we are looking at it. I think Bill suggested this as well. One of the questions is, back to innovation, what is the correlation between concentration and innovation? And we don't know the answer to that, but we've been looking at it, and I think the FTC looked at it in the pharmaceutical area and some of the analyses that it has done. I think that it's not just we're looking at that, Senator, but actually to look at it, but not waste all the agency's resources going down a blind path. I think that some of the work, particularly done by the FTC and also by the department, has been very good in these areas of question. But the answer to there's never going to be a satisfactory answer to someone who simply says, "Go use antitrust to create equality across the world." That person's going to have that view, no matter what you say. And I think that one has to come back and say, we're looking at any angle that has an antitrust root to it, and we're examining it. But if the antitrust doesn't answer the question, then we should not be afraid to say so after making that analysis.
Bill?
Just briefly, sports analogy, you're remembered for the wide open receiver you overthrew. Not for the fact that you went 8 for 12 passing in the first half. I mean, that's we're big boys and girls. We had a chance to do stuff. We did well. And that stuff gets underappreciated as people, particularly in this volatile electorate. You're talking about a situation where many people do perceive income inequality and unfair treatment. They're going to focus on the problems. They're not going to spend time patting us on the back, and we should get over expecting that. I think, the better question is the one you framed up. What is it and that we can appropriately do to make a difference in addressing these concerns? And are there some, is there some legislative tinkering that needs to be done? Senator Klobuchar has a bill talking about changing substantially lessen to materially lessen and enumerating some factors in addition to short-term price effects. Do the courts and the agencies need a little more guidance about how to bring those kinds of cases, including potential competition cases? I think, again, back where I started, those are things we ought to be taking seriously. I appreciate that no one in this room seems to hold the view that antitrust enforcement is the answer to every question that anyone has ever raised, not just in the last year, but in the last 30 years. But at the same time, continuing to focus on those incremental things which we can do better, which the courts up till now may not have seen within the scope of the antitrust laws. If we can come up with an analytically sound framework so we're true to first principles, we ought to be doing that.
I don't think anyone on the panel is suggesting that Senator Klobuchar ought to be ignored. But the question is, what is the impact of what is the suggestion there, for example, changing from substantial lessening to materially lessening? Is there a need to change that, and is there a case to be made that more harm can be done by changing that standard than by keeping the existing standard? And I think those are legitimate questions to ask. But they're not necessarily questions where one has to agree for this political purpose of agreeing. I'm not sure you're not suggesting that.
Absolutely, and I'm in agreement with you on the fact that there needs to be a debate about that. But the fact of the matter is, if you look at the way we've disciplined ourselves as antitrust enforcers over the last 25 or 30 years, we have committed to a level of confidence that our theory of harm is, that we're highly confident in our theory of harm, that arguably may have produced some under-enforcement. I think, again, that's worth talking about. What I understand that part of the Klobuchar legislation to be doing is suggesting, maybe on balance in this economy, that moving the risk a little bit in favor of the possibility of over-enforcement is not such a bad thing. And when you look at the evidence that with large mergers, the evidence casting doubt about whether efficiencies are achieved, whether efficiencies are actually passed through, what's the risk we run by moving the needle a little bit more towards more aggressive enforcement? You would probably need legislation to do that, and I think that's worth talking about.
But the fact is, you want to ask the question, but don't answer it by asking the question. The fact of the matter is, we are, for the last number of decades, making successive changes in analysis, some of which were more pro-enforcement oriented. I think adding the unilateral effects analysis to the 1992 merger guidelines was a pro-enforcement, might have been too much, but a pro-enforcement analysis, pro-enforcement step. We are doing those things, but and I'm not suggesting you're saying this, but to take a blind eye and saying things are wrong without the empirical basis of determining that things need to be changed makes a big mistake and can do considerably more harm than good.
Well, we agree on that. It's really, you and I are in that classic glass half full, glass half empty thing. I'm not suggesting we amend the antitrust laws without strong empirical evidence to support it. I am suggesting, though, that though there are questions that way to look at, that there is a judgment call that goes into what we can lawfully bring as a challenge under the antitrust laws today that probably causes enforcers to be somewhat risk adverse and to err on the side of under enforcement. And is that having a consequence? Is that the right place to be? It may well be, but I think we ought to have that debate.
I mean, when you look at the framework of doctrine, I guess to come back to a point I think you've suggested, Bill, if there's going to be an expansion of the system in its scope, in its reach, will that have to come through legislation? In theory, I suppose it could come by applying existing jurisprudence. As you know, the Supreme Court has not weighed in on a question of substantive merger policy since 1975, a mere 42 years ago. Who would have thought, even with the coming of Hart-Scott, that the court would be disengaged for so long? I suppose they would say, you don't bring us the right cases. Steve Breyer, at a program we had for the FTC's 100th anniversary, in an interview here at GW, said, I'd love to have a merger case. So at least for some members of the court, it's not for want of having a chance to engage. He's saying, we can't make up cases that we don't have, so bring them to us. But if you go back to the jurisprudence set from Brown-Shoe in 1962, certainly up through Ford Autolite in the vertical area in 1972, the decade of jurisprudence, it's welcoming of a broad multi-goal framework. The Brown-Shoe discussion about the vertical merger features, where the Supreme Court says, Brown-Shoe, you might be right. The vertical dimensions of the merger could increase output, improve performance in different ways, but that's not what Congress wanted. Congress wanted, given the choice between more efficiency and decentralization, it picked decentralization decisively, and we must give effect to that choice. The Supreme Court has never repudiated those words. It's never repudiated the suggestion in Procter & Gamble in a merger case that says, if you're going to tell us about efficiencies as an offset to any competitive effects, get out of here. We don't want to hear that kind of argument. You had structural thresholds that strike us as quaint today, but the court never repudiated them. You can say that its later jurisprudence in other areas was skeptical maybe of some of these views, but it's there. Would any enforcement agency today, would the head of an agency be willing to walk into district court with the prospect of going up through the chain of appeals that we have now and go in and say, by God, they got it right in Brown-Shoe? That is the concern about the legitimacy of the political process, the undermining of the economy and the political process that comes with aggregations that diminish the role of smaller firms. They got it right. It's been dormant, but it's still there, and we mean it. And you could say the same thing about potential competition, about the treatment of efficiencies. Do you think there is a head of the agency today or tomorrow that would walk into court and say, that jurisprudence from 62 to 72, never repudiated, is good law, and I mean to use it today? Would anybody do that?
I've got scar tissue. When I took over as a division, a lot of the trial tactics on merger cases were to go into district court and say, Philadelphia Bank, concentration, we win, you lose. We lost 4 straight cases on those arguments. That's what one of the generators of the 1992 guidelines, actually, to get away from just that pure structural analysis. No, the Supreme Court has not repudiated Philadelphia Bank. Actually, you can read Philadelphia Bank to live with current theories of antitrust. I think it's more difficult to read Brown-Shoe small business UCAS. But no, Bill, I wouldn't do it again. And that was a major effort to revise the type of argumentation that we would use to tell a more full and more complete story after the loss we had in Baker Hughes' horizontal drill case.
Jim, should we have gone up to the court in Baker Hughes?
I wanted to.
Yeah, I mean, you.
The Solicitor General had
clear
a
it.
different
Two
view.
people on that panel got promotions, and they're still on that.
Well, I mean, it was a heck of a panel to take up since Clarence Thomas wrote the Court of Appeals decision.
And Ruth Ginsburg joined along with no
Ruth Ginsburg was
qualification,
on
including that last footnote
Yeah.
that pokes the department right in the eye for using its ponderous resources.
I think that's a case. I think that's a case we should have won, but the Solicitor General had a different view on taking it up, and I respect his opinion.
But should have that been the occasion to go up to the court and said, you guys, as part of your responsibility, you are the basis on which doctrine is adjusted over time. By design, that's what you do. But you've got to give us some clarity here about what this statute and what this framework means.
You're singing to the choir.
Yep. That's a bit of a regret that they didn't come in on that. But would we agree that it would take an extraordinary amount of fortitude by the head of an institution to go into court today and say that the words and the music of Brown Shoe, of Procter & Gamble, of Ford Autolite, that those have vitality today and we're standing on them until we see the Supreme Court. We don't want to hear from the district courts or the courts of appeals, which the last time we checked in the hierarchy of authority are inferior courts, not the Supreme Court. We don't want to hear from that. We've got the power there. By the way, this is part of the critique. It's there. You could use it. It's a vehicle not driven lately, but it's there. That would be futile with this court. That if you got to the big court, they'd say, thank you for the chance to revisit this, and we rethought.
I think that would be a wonderful thing for the court to do. And you look at some of the court decisions that have come down, well, everybody knows this, I mean, from Trinco on. The revisitation of merger law might be a very, very useful thing to do. I was hoping that the court would, that the Solicitor General, the Assistant Attorney General would want to take up the 3M yellow sticker case from the Third Circuit, which I think was an abomination of a decision with all respect. But I think there's a bit of risk aversion there, Bill, that I think you're hitting on.
Let me give you each a minute for additional thoughts to ask. If you're going to add something to the mix going ahead, and I think you've addressed this already, anything else you haven't mentioned already that you would add to what's taking place now in the critique? We've talked a bit about evaluations. We've talked a bit about possible adjustments in the way in which cases are pursued or development. Anything you'd add to the mix, again, to respond to the larger critique?
Very quickly, I think that in my opinion, what we should say is, as we face this critique, take it for what it is. Do not say, no, we can't do it. But where something's clearly outside the realm of antitrust, I think we should have the courage to say so if we believe that, and not and say we will look at whatever antitrust tools, mechanisms, theory, analysis appropriately can be brought to bear, but we're not going to solve all the problems of the world by antitrust.
Jeff?
Well, I think it's very important to take the critique seriously on the one hand, but perhaps focusing on the political aspect of the critique in particular. I do wonder whether we have to be somewhat cautious not to overreact to the critique, meaning that seems to me to be a political aspect to this, that if you look at the difference between what you hear as a reaction when you testified before a Senate or a House panel versus what I heard when I was talking to the staffers in a closed-door meeting, that it was a very different picture. A very different discussion was taking place.
We should have traded positions.
So I just throw that out as a possibility that, you know, again, it's the critique, certainly something to be taken very seriously, but recognize that there are some factors that could be at play, particularly on the political side, that really are just beyond our control.
Aviv?
To me, I think it's ultimately going to boil down to what the data show. If you're going to make the case, look, we've put the thresholds too high, you need to go back and say, look, here's a whole bunch of mergers that would not have gone through under this standard, went through under this standard, and they were bad. And not just, cherry pick one or the other, you're always gonna find that. But show kind of systematic evidence that's the case. I think that's what you're gonna need if you wanna make that plea to go back to the Supreme Court, and that's what you're gonna need if you wanna push back on people who claim you should be doing that. I mean, you can shut on the other side and say, look, you haven't shown me stuff, but I think you do need to kind of systematically look at that.
Yeah, Bill.
Well, I just 2 quick points. One, to reinforce something Jim Rill said about making sure the competition authorities are actively involved in sector issues and promoting competition. You look at the potential for anti-competitive, anti-consumer outcomes in healthcare, transport, those sorts of things. Those are potentially real dollar value benefits to consumers from competition, and to have the agencies using whatever clout they can muster is a good thing. Another area we've talked a lot about, things that ought to be looked at more. I do think this issue of, as industries get concentrated and there's more common ownership, is that contributing to less competition? And I think we had mentioned that before, but another area where I think we could legitimately focus some attention.
A last thing to ask before we take a break. Your thoughts about how to carry this kind of discussion forward. That is, the way in which the discussion among those who've been deeply involved in the enforcement process over years, with policymakers, with those who have such forceful objections to the direction of policy in the path. Is there a way to promote the debate, the discussion, the conversation that some of you have been talking about going ahead? How would one do that?
For one thing, you're doing it. Programs such as this, I think, could be very helpful. But I think the people in the antitrust community and the business community generally need not to be afraid to stand up and tell that side of the story. And the debate can't be simply one-sided. And I think a case had to be made for the benefit of antitrust, the extent to which it does promote both the dynamic and static benefits, to the extent to which it promotes innovation, the extent to which it promotes efficiency and benefits consumers, needs to be told. Not that we're all right, not that we've done everything right. And I've talked about some of my mistakes. But I think that the debate right now, the noise of the debate, seems to be too much of a crescendo on the other side. And those of us who may have some questions about some of the proposals being made need to stand up and talk about it.
Bill, just real quickly, it strikes me that we spend at the agencies a great deal of time focused on foreign countries, foreign competition authorities, and doing all kinds of outreach and training to them. And I wonder to what extent that some of that effort could be redirected toward domestic sources, such as Capitol Hill, where there might be the opportunity for more of a regular dialogue instead of in the context of a crisis or a big political issue, but where there's real training going on. I mean, you are always, we joke about you always being on an airplane going off doing training around the world, but have you been up on the Hill, doing similar training?
It's a much longer journey. Aviv.
Because they should get frequent flyer miles for taking an Uber over to Capitol Hill. I don't really have much to add. I think, I'll say what Jim did, which is I think more events of this sort, getting academics involved and speaking up.
No, Bill, any other?
Well, first, I would love to have not your miles traveled, but your United Airlines status. I think a couple of planes are named after you. But to me, one of the things, conceding or reemphasizing the point I made earlier, which is in this kind of environment, you can't expect to fight back effectively with the defense of everything you've done and expect people to listen. There's a lot of legitimate emotion and concern out there about income inequality. That said, doing a good job of pointing out where vigorous and persistent competition enforcement has made a difference. Somebody mentioned hospitals earlier. Pay for delay. You know, the persistence of the agency over Republican and Democratic administrations in getting that principle accepted by the court, by the Supreme Court, was terrific. Pointing out the benefits of successful challenges. What happened to the wireless market when AT&T abandoned the T-Mobile transaction, and when it became clear to Sprint that they weren't going to come in and go from 4 to 3. Talking about those market-based effects actually, I think, help improve the consumers and the politicians' understanding of where effective enforcement can make a real and everyday lives difference to the average consumer.
No. Please join me in thanking Jim, Jeff, we have coffee and some snacks in the back of the room. Let's resume in 15 minutes, please. 10 past.
Hey, Jeff. Really nice meeting you. Thank you. Okay, thanks.
First question, I guess congratulations. So you had stage, how does it go? But ultimately, this really shapes case law going forward. And one thing that's going to is how cases brought may impact the next set of cases. What you it's a process. You've thought about this long and hard. You but you haven't.
The promotion, so we've got something like the standard
Yeah, I was just saying that some like how do wins and losses impact sort of the next generation of cases you can encounter. Thinking big picture, this gets lost in the broader debate of why standards is not as expensive as it used to be, but give away all kinds of consumer data like why standards.
But the second one very good sort of the final point.
The importance
And that is, I think, one of the reasons
the importance of thinking about getting the program that you can or to advance the law.
You've got the second regulatory entities. They're not going to be the ones looking at it because they don't have the broad mandate. Look at the economic agencies that are actually doing the big one you look at. There isn't anything else like it really is where we're going. And so plants are taking shots, businesses are doing something right.
Actually, how much of an applicant's because that's one of the large but we don't get that from the populist element. And so why don't we see consistency? Or if what we're concerned about is income inequality, we shouldn't go after Christie's and Sotheby's. Not sure if they were compliant because actually, when rich people are ripped off by other rich people, or even simply, we have unambiguous Supreme Court.
Good handle.
I have your tweet down.
Look, I can, you can come up with
Oh, no.
like, yeah, let's
It's basically based on the years of the Senate Commerce Committee. When the Senate worked for us, and he says he's now going to go back and write about the time period you're talking about. 77, yeah, I know. Yeah, no, but he talks about that in the book.
That was great, guys.
I'm going to throw him for a little bit.
No, I mean, in some ways, I don't.
How are you? Good to see you two all. This is like a little reunion. I feel like I'm sitting in your office.
You should be on notice that you're on we didn't.
I feel like all of those things, right? You know,
I was a little bit upset.
and I'm going to guide you.
Well, one of the things he is kind of
When we think agents,
and I'm happy to do that. But the problem is that you don't get a lot of time. Things good. Things are good. Making a final we had obviously the outcome was different. There was no argument. It didn't matter. The judge actually they tried to
I don't think that it's but you were doing it, I was adjacent to it.
yeah.
Are you just down for the day?
Well, you know, I've got that's the house.
It's been recorded and streamed, so the recording will be on the website. Yeah. GWS, law school. Should be in the press, the media relations, yes, and maybe 2 weeks or so. My 40 plus or minus posts. Yes, yes.
Yeah. I know, I was a little late too. We're gonna catch us up by it.
Hey, Bill.
David, they'll say
There is literally
Could have been much worse.
I am good. How are things over there? How are you?
That's it. That's working. There's so much fun. Let's get that right. So It's like published like an hour ago. So it's basically describing the.
I don't know about that.
Yeah, she's in it.
What's that?
Yeah, she writes.
Yeah, we can follow.
You know,
Right, well.
I mean, I think timing would be. People just, I guess.
Well, so my
Yeah, yeah, that's it. I think it's just licensing. But I think it sounds
Oh, that's right, I did hear that. She was very impressed.
New one.
Yeah, so 4 o'clock press conference with Megan Delrigan today. With the market close. Yes. Oh, it's probably starting right now. Yeah. I wonder what they're announcing. We live in interesting times.
Actually,
but you know what? You know, antitrust is not as politically driven as people think. Bill was the person who believed that pharmaceutical settlements should be per se illegal, as I recall. Got it wrong. Good enough. So? You're going to be surprised about the answer? I don't think it'll be surprising. And I suspect it will be mostly in the same place. But you never know.
Not sure what order Sandy would like us in, so we're just kind of aligning ourselves. He's got one. I'm going to sit with him.
I was honored to work with you, actually, Bill.
Both people named Bill are very powerful.
What's your daughter's business?
She's married. She's in Seattle.
The last time I talked to you a couple years ago, she was.
Yeah, probably not. She's married to this guy from Microsoft. She,
You have your resume?
he doing fabulously well with the Azure product, also known as the Cloud Computing product. She is doing fabulously well with a strategic consulting business. With a boutique strategic consulting firm based out there. It's called off like McKinsey and Bain. She's the IT person. Would you like us in any particular order?
How do you want to do it? This is like McDonald's. We can make it your way.
Yeah, we have that.
John, any first or last?
I don't care. Anywhere you want to go.
Andy didn't respond, so John, congratulations, you're going first.
Yeah, John. Well, then let me look at it.
I deferred to John.
You never did that when we worked together.
Yeah.
In fact, I hired you for your insubordination. Just wanted to be challenged, just every day. By the way, Very bright.
If I could ask everyone to get back to their seats so we could get started.
Just my daughter is he's not started. So his wife.
I want to thank everybody again for staying for the second session. This is equally important as a session, much like Bill in the last session. I have really a spectacular group of practitioners who really have helped shape antitrust law for more than one generation. We could say in terms of different presidencies. I've got John Leibowitz, former chair of the FTC. I have sitting next to him, Bill Blumenthal, former general counsel of the Federal Trade Commission. Next to him, I've got Debbie Feinstein, former head of VC. I have Andy Gavel, former head of the Office of Policy and Planning, and also lead author on the leading antitrust casebook, for which Bill also happens to be a co-author. And then I have Renata right next to me, also known as the last Democratic Assistant Attorney General. So
For now.
yes. Right. So it's that. And we're going to go through similar yet different issues, and we'll move from John to Renata for the first set. Which builds off of our last session. Do we need to somehow change antitrust statutes? Because this is what's in play right now, potentially in Congress. Do we need to somehow change antitrust case law, which has, I think, always been in play? Or agency practice, again, I think it's always been in play for effective enforcement in mergers and conduct. And John, I guess among your many wonderful feats and backgrounds, I should have also added, you understand this from the legislative side, in addition to the agency side. And so maybe you're a great person to start with because you wear multiple hats.
I have to wear multiple hats to cover my bald spots, growing every year. So I'm happy to. Danny, do you want me to start now? Is that an segue, or do you want to say more?
No, I get a few minutes at the end to wrap up. So
okay,
please go ahead.
So, am I on? Yes. So I'll try to be very, very brief because I know you want to save a lot of time for questions, and I'm sure we want questions from the very distinguished audience. So look, I am a big believer in the value of periodic debate about the meaning of antitrust and the power of large.
I can't hear you in the back.
Ah, so sorry. Can you hear me now?
Yeah.
Can you hear me now? Okay. So I am a big believer in the value of periodic debate about the meaning of the antitrust laws and the power of large corporations. The House, in an article that Danny shared with us, Professor Sokol, said that it's about to start an antitrust caucus. I think that's a good thing. In 1912, 105 years ago, Louis Brandeis, one of the architects of the FTC, told the congressional committee, and these are in hearings on the steel industry, we can't maintain democratic conditions in America if we allow, this is a quote, organizations to arise in our midst with the power of the United States Steel Corporation. Liberty of the American citizen cannot endure against such organizations. That's before the House Committee on the Investigations of the United States Steel Corporation in 1912, known as the Steele hearings. I think it's good to have that kind of debate. And I think the present debate among Democrats and a few Republicans is raising important ideas. But having said that, I don't think that means that the law needs to be changed to address some of the issues that they've raised. The premise, to my mind, the premise that large tech companies have amassed a lot of power, or market power, is probably correct. There's some good ideas in the fair deal competition platform that the Democrats unveiled last summer, including things like updating this is not radical, but updating the Hart-Scott-Rodino fees, requiring post-merger companies to come back to the agencies and explain how their deals benefited competition and consumers. But look, network effects also sometimes create positive efficiencies that benefit consumers. Whether it's unlimited minutes with others who use the same phone carrier, or being able to post on a single social network rather than using multiple platforms. And I don't think we should be concerned so much about companies getting market or monopoly power from developing a superior product. Where network effects, and I learned this from Professor Kovacic among others, and barriers to entry become problematic is when a dominant company uses its monopoly power to exclude a rival or engage in exclusionary conduct or vertically integrate in a manner that's likely to exclude competitors in the future. And so, I think Section 2, Section 5 of the FTC Act, and Section 7 really do provide the legal authority that agencies need to stop inappropriate conduct and conduct that harms consumers. And of course, you have to enforce those laws, and you have to enforce them vigorously. My sense is that the recent record and I don't start in 1980. I probably started in about 2002, 3, or 4. But I think that the recent record on antitrust enforcement is pretty good under the standards we already have. If you look at merger enforcement, and Debbie and Renata certainly know this, over the last 10 years, the FTC and the Justice Department have won, I think, the vast majority of merger cases that they've challenged. And then that was after a period, I think, from about 2002 to 2008 or 2009, where we had won very, very few. The FTC, thanks in large part to people in this room, has stopped the worst abuses by a handful of pharmaceutical companies, not all pharmaceutical companies, so-called pay-for-delay settlements, in which generics, brands pay generics to stay out of the market, and consumers were left holding the bag. The Bureau of Economics estimated that American consumers would save $3.5 billion annually if those deals were stopped. And I think the Actavis case and follow-up activity by the FTC has done that. And it's also worth pointing out that the cases that led up to the Supreme Court challenge and the FTC's victory in Actavis were brought by commissions led by Bob Potosky. And I think I see Bill Baer sort of in the back with a beard there, and Bill Baer, Tim Uris, Bill Kovacic, and that's pretty bipartisan. And it seems to me to be a perfect example of the FTC and Debbie Feinstein. It seems to be a perfect example of the FTC devoting resources, to the greatest good for the greatest number of people. The FTC brought successful monopolization cases against Intel, against Google, Motorola Mobility. I brought a case before it did not win against Rambus. And you might say Qualcomm as well. Consider what the Justice Department, and we're missing the press conference right now, but consider what the Justice Department is announcing at this very moment, which is it's challenging AT&T Time Warner. So Do I worry about excessive concentration in a few industries? Of course I do. Do I wish I had a vote or two back? I probably do over my 8.5 years. It was the 1 or 2 times when Bill Kovacic said, John, I don't think you should vote this way, and I didn't switch. No, do I wish I had a couple of votes back, or maybe we pushed a little harder on something? Possibly. But it would be a big, big mistake, I think, to replace a consumer welfare standard with a public interest standard, or to try to socially engineer antitrust to achieve even very worthy goals like reducing income inequality. Antitrust, and I'm not so sure that's going to change, but antitrust is probably one of the few remaining areas where there is, up until recently, certainly a relative bipartisan consensus. I think that's a good thing. It gives more predictability to businesses. It encourages respect for the judgments of an American or of American institutions. And so when I ask myself, was it all that bad? I think my answer is no. And while antitrust enforcement, antitrust policy over the last couple of decades was certainly not perfect, I actually think it was pretty good. And with that, I will quit bloviating and turn it over to my colleague, Mr. Blumenthal.
John, thank you, and good afternoon, everyone. About 33 years ago, in 1984, there was a great article in Georgetown Law Journal by Fred Rowe. Not many people read the article at the time. Fewer of you probably remember it today. Not too many people remember Fred Rowe either, but he was one of the leading practitioners of Robinson-Patman in the 1950s, 1960s, 1970s, back when that really meant something. That was real business. I mean, there was a time when the firm we now know as Kirkland & Ellis operated under the brand Kirkland, Ellis & Rowe. That's how big Robinson-Patman was at the time. But Fred had an article in '84, towards the end of his career, with one of the best titles I remember from the time, the delusions, the decline of antitrust and the delusions of models, the Faustian pact of law and economics. And the basic thesis of the article was that antitrust had its roots in social and political considerations, Grange movement type considerations. But there came a time in the 1950s when antitrust, looking to give itself a bit more of this sort of patina of scientific rigor, embraced economics. And embraced economics at the time when we had the Joe Bain structure, conduct, performance type of paradigm that was entirely consistent in its direction with the same type of social and political urges that one would have heard from the Grange. But economics, of course, changed. And when Rowe was writing in '84, we hadn't had as much of a movement as we've had today. But Bork was taking effect, Posner was taking effect, the Chicago School was taking effect. And antitrust was deviating at that point from the social and political original impulses. Well, in the intervening 30 years, economics has gotten even worse. I mean, in the sense that it's become a much more mathematical field, it's become a much more hyper-technical field, and I would suggest to you that antitrust, yoked as it is to economics, has also become much more hyper-technical and much more mechanical, mathematical, detailed, analytical in the way that the priesthood in this room would be. But in a way that deviates pretty significantly from the original conception. So, we've become very effective as technocrats. We've become very effective in cases with things like, name one case I had, automatic feed, low volume plastic card embossers, with tippers and without interfaces. Surgical strikes into remediation of narrow pieces of the economy. And we're doing it very well. But it's not the most intuitive outside of the, say, 8,000 members of the ABA antitrust section, right? All of us who deal with clients have had the experience, I'm sure, of getting on the phone with a business guy for the first time and hearing, oh yeah, this will be an easy deal because they just cleared and pick some random large case in his industry, right? We just cleared a mammoth chemical industry merger, and it falls upon you to say, well, sorry, but you've got an issue in dimethyl dichlorosilane. And we're going to have a problem because of that surgical strike. And the person says, what are you talking about? What are you people talking about? Where is antitrust these days? Now, we're not the only discipline that has technocratic impulses imposed by bureaucracies that operate as echo chambers, right? I mean, every time you watch, CNN, you undoubtedly see advertisements for pharmaceuticals that have a laundry list of side effects, something that could not conceivably be an advertisement except from people who don't understand the difference between an advertisement and a product label. And you can just kind of go through the litany of bureaucratic cases, cases involving sort of EPA excess relating to wetlands, cases involving arrowheads found on Indian sites. The Yates case in the Supreme Court a year ago relating to the question of whether a fish was a tangible document within the meaning of Sarbanes-Oxley. Right? All of these cases brought by bureaucracies operating in a technocratic way. But when you think of our business, right, in a world where you have now giant corporations with market caps in multiples of $100 billion, disrupting large segments of the economy, and you look at what the government has done in the area of monopolization, right? I mean, what do we have to show for the last decade? We have a hospital case in Michigan. We have a physician group case in Oklahoma. We have another physician group case in Texas. And that's our Section 2 jurisprudence at the federal level. In a world where half of the public is now getting its news from social media, we have the government of the United States last year filing briefs in a failing newspaper case, contending that newspapers do not face competition from the internet within the meaning of the antitrust laws. And it's things like this that lead people outside of the priesthood, people up on Capitol Hill, and large numbers of the body politic to take a look at the antitrust bar and take a look at the antitrust laws and say, where are your heads? Now, the practical effects of change are less than obvious and are probably things that people really need to think through. So I'm not advocating the change, but I am trying to explain the motive for the change. But if you think of what are some of the permutations, well, merger efficiencies, right? So suppose we have a merger that's going to have very significant efficiencies in the form. We all have the joke, right, about going into the agencies with somebody and saying, hey, right here, this is one of the merger efficiencies, haha, because Debbie's going to lose her job as part of the deal. Well, suppose you have a deal that has, you're going to take out 15% of the labor force and reduce cost by 10%. Well, is that good or bad? Obviously, in this world, that's great. 10% reduction in cost is a massive amount in a merger. And yet, to an awful lot of people, that's the opposite of what these laws ought to be about. Another one, cartels. I think, while we're in under the hood, why don't we talk about cartel policy? If we're going to talk about Section 2, if we're going to talk about mergers. One of the collateral effects of cartels, two of the collateral effects of cartels are higher wages and stability. Right? When, the United Auto Workers did a lot better when we had a three-firm oligopoly in the United States. The trucking industry, when it was a regulated industry with mandated pricing, was much more hospitable to the Teamsters. Teamsters' wages have collapsed in trucking deregulation. If you look at the airline industry, it's been terrible for the pilots, for the flight attendants, for the machinists. It was this century, 15 years ago, that at the OECD, you had Switzerland talking to the U.S. rep at a section on optimal cartel sanctions, and saying, we don't understand what the United States is talking about in cartels. From our perspective in Switzerland, cartels introduce social stability and avoid some of the disruptions in society that you have from vigorous competition. And obviously that's a view that one historically saw frequently in East Asia. It's a view that one also saw in Germany. If one is going to open up the rule book in the United States, that's probably one we ought to talk about as well, in part because there's a duality. We keep talking about consumers, but it's not a closed economy, but the reality is that most of those consumers are also laborers. And to the extent most of us are beneficiaries as consumers, well, we're also disadvantaged from the vigors of competition wearing our laborer hat. Right? It's the same sort of analogy one has, what the one is seeing play out on the trade side. Now, if you ask me what I personally believe, I think things have worked pretty well. I think that we have it about right. I think in particular, the ill-formed standards that would arise with a shift in policy would lead to an extended period of uncertainty and unrest. The administrability problems of going outside of mainstream economics are severe. But ultimately, these are political judgments. And I suppose the main thing that I would urge is that Congress, in making the political judgment, be mindful of the cost that would be imposed through some of the proposals that are being suggested now. You go back to Philadelphia National Bank, and there was that wonderful section in the Brennan majority opinion, often attributed to Posner, the clerk, where they spoke about how Congress, in adopting a Derek Bach type of test, and adopting a market share based test, intended to bar mergers with significant share, benign and malignant alike, mindful, we must assume, of the resulting costs. And the resulting costs, I think, are sort of what people in the back of their mind have at sessions like this. But I would respectfully submit to you that there is probably a discussion to be had up there. Danny?
Thank you, Bill. Debbie?
Okay, so, I came at this from sort of a pragmatic point of view, which is first, do we need to change case law, statutes, or agency practice? So the first question I asked is the government losing? Answer clearly no. Certainly not on the merger side, and I want to talk about that. for a minute to begin with. So I'm just looking over the last couple of years. Those are the cases that I know the best, and thinking about those cases. Staples and Cisco, both clear wins, and I think they stood for a couple of propositions, which is a way that I think the case law has moved in a way that's embraced the guidelines. You know, they made the point first that unilateral effects alive and well, something that was not where the law was maybe 10 years ago. You know, H&R Block, I think, sort of started it, but then it's been continued. Both used the phrase targeted customers. I don't think that had come up before. It was quite clear that while the courts were a little confused about how to think about it, is it product market, is it geographic market, where does that fit in? They embraced targeted customers full on. They rejected litigating the fix, an issue that was, again, in dispute some number of years ago. How did you think about litigating the fix? Was it that you had to think about it as a new deal? Was it that you looked at it as something after the government proved its anti-competitive case? And I think the courts, you know, continue to talk about those kinds of issues. And then finally, they dismissed efficiencies and other pro-competitive justifications. So, you know, does the law need to move? I think it clearly has. I think that the courts have embraced things that were not sort of part of the law years ago. You know, folks can debate whether that was, you know, good or bad to go in the direction that they are, but that's clearly the direction they're going. So I think the case law always does move, and I think the government's done a good job of moving the case law on mergers in the direction that it wants to. Now, the FTC lost a bunch of cases too. I mean, at the district court level, it was kind of 50-50. They lost, during the time I was there, 2 hospital cases. Those got turned around by the courts of appeals. And they lost those cases despite the fact that there was, you know, pre-existing Sixth Circuit law and Ninth Circuit law that was pretty favorable to the FTC's case. And the district courts there still had concerns about it. But the Third Circuit and the Seventh Circuit very much went the way of the Sixth and the Ninth Circuits and said, among other things, Elzinga-Hogarty, which Professor Elzinga himself says is not the right way to think about geographic market in hospital mergers. You know, the death knell, if not there, it's awfully close. So again, that's another example where the case law was very bad for the government for a very long time. The government went back, they did retrospective studies, they thought about the bargaining model differently, they brought these cases again, they lost at the district court level, but they went to the Court of Appeals. And so again, I think another example of where the case law is moving in the right direction from the perspective of the government. And then finally, the FTC lost Steris, which was a potential competition case. But the court made really clear that they lost it on the facts, not on the law. He took the fact that there was a potential competition doctrine as a given and basically looked at his view of the facts. So the question is, if you go back, you know, should the law have been changed on any of those from a statutory perspective? I think almost nobody would say, yeah, the right thing would have been to make a statute saying that targeted customers are a way that you can think about this, or a statute saying that Elzinga-Hogarty shouldn't be used in geographic market cases. I think the normal case law evolution is probably what most folks would say is the right way to get to the results that the government got to. So it's hard to think that you need to change the case law for those kinds of cases. It's worked itself out, although it meant losses along the way. Of course, the question is, the law is sort of what the law is. Are there cases that the government isn't bringing because it feels constrained by the law as it exists on mergers? And I have to tell you, I'd be surprised. I mean, you know, the one thing that you can always see with the commission is what the close cases are, at least among the commissioners' perspective. I mean, I find it intriguing that Cisco was a 3-2 decision. I think the court at the commission, the court pretty decisively said, oh, this is an antitrust violation. In Steris, it was a 5-0 decision to bring the case. All 5 commissioners went along, and you know, the court viewed the facts differently. That is what it is. But you go back and you look at how few cases there were that there was case that was not brought where a commissioner had an objection about that? Because I think those are sort of the interesting cases to look at. Should those cases have been brought? And does the case law, was it the case law that suggested otherwise? I mean, the one good example was the case of the tobacco merger that happened a couple of years ago, and Commissioner Brill dissented on that case. And remember, this was a case where the parties had simultaneously entered into the merger agreement and a divestiture agreement. And the commission in its statement said, we think this divestiture agreement will solve the concerns here. I don't think there was anything that you could read in those commission statements. At least I don't read anything in those commission statements to say we're on the fence, it's a close case, but it's the law that's preventing us from being in this case. I think it was really different perspectives on the facts, which is what led to the difference. So it's hard for me to see that on mergers, a case law change would matter. Some say, well, we ought to shift the burden and the presumption. I can see how that would make sense if courts were routinely accepting the pro-competitive justifications of the parties or efficiencies. Then maybe there'd be an argument, a debate that we can have about whether or not the presumption needed to shift because the courts were getting it wrong. But the courts are, just constantly dismissing efficiencies in language stronger than any agency official will ever talk about it. I mean, agency officials talk about the guidelines and how efficiencies ought to be considered, and the courts are much more stringent on efficiencies than they are. So it's not clear to me how changing the burden of proof would matter. And then one final comment on the conduct side, and John mentioned the reverse patent settlement cases, because I think this is a really interesting case study. I mean, for years, the commission was having challenges, and there were courts, plaintiffs in general were having challenges. There was the scope of the patent test until we went to the Supreme Court. Since then, circuit courts have given the plaintiffs, both the government and private plaintiffs, a number of victories. And again, I ask, is it better for case law to have evolved, or would it have been better if a statute got put into place 10 years ago, basically saying they're presumptively unlawful? I mean, I think that one can reasonably debate about that, but I think the point is that the case law has moved in the direction that the commission wanted it to, and that might be a better way to go than every time there's a concern or a loss for a new statute to be implemented that deals with a particular loss that governments or private plaintiffs have.
Thank you. Professor Gavel.
Andy is fine. Good afternoon, everyone. Thank you, Danny, and thank you, Bill, for inviting me to be here. I want to address directly this question of should the statute be amended. Start by saying, sort of echoing a comment that both Aviv and Bill made this morning, it's assuming there's a case for it. So assuming there is a case for it is my way of saying I don't see the empirical basis right now for why the statute has to be changed. But assuming there was a basis for it, focusing on the statute, I think, misses the mechanisms that today make merger policy. It's not the statute. The statute was last significantly changed in 1950 to respond to perceived weaknesses because of some Supreme Court decisions. But since 1976 and the advent of the Hart-Scott-Rodino system, it's the agencies and the guidelines where merger policy is made. And to a large degree, having taken time, and it took a long time till the merger guidelines were accepted by the courts, the merger guidelines have become sort of the way that we fill the vessel of Section 7. That same statute supported Brown Shoe and Pabst and Bonds, and that same statute now supports all of the cases that Debbie was mentioning. So I'm not sure that going back to the statute, which has obviously a lot of flexibility, is the way to address concerns that we have today. If we do have concerns, and I think Debbie articulated it very well, the way to approach the concerns would be, after having some empirical basis for changing something, to think about test cases, which are hard to bring and take a while, and they have risk of loss, especially if you are trying to move the law in the direction of greater protection or greater aggression. It is a lot easier to move the law in a different direction. But if you wanted to move the courts in that direction, you would need careful cases. You would need to think about how you would revise the guidelines to support cases. You would need academic commentary. And all of that, to me, suggests that 2017 is not the world of 1982 that Bill Baxter walked into. I was thinking when Bill was talking about Perchuk in 1977, there's some irony to where his head was in 1977 because the antitrust world was changing around him in ways that he wasn't talking about in that speech. Sylvania had been decided that year. BMI came 2 years later. The election of Ronald Reagan a year after that. So when Bill Baxter came in, he had a generation. The Chicago School didn't affect antitrust in a day. The Harvard School didn't affect antitrust in a day. A year after Perchuk gives that speech, The Antitrust Paradox is published. The first Arita Turner treatise is published. It took a lot of development of the academic side, the theoretical side, the criticism of the prior cases, and changes in the Supreme Court, the 4 Nixon appointees. When Bill Baxter came in 1982, he was in a much different position. And the criticism that we're hearing today is, in a sense, just beginning. It needs to be tested. It needs to be thought about. But at the end of the day, I don't think it's the statute where change will come. The change will have to come at the agencies and in the guidelines, which is how we go about the process of merger policy today.
So thanks for all of you for hanging out. Well, I've been watching my BlackBerry rudely just to see if the case has actually been announced, but so far nothing's out. So thanks for sticking out. It is, I guess. All right. So there we go. So I thought and this sort of comes from the prior panel a little bit. So if you missed that one, this might not make a lot of sense. But we heard a lot about are we doing things the right way? Do we have the economic tools we need and the like? And I actually think the question we ought to be asking is, are we measuring the right thing? And if we're not, how do we go about measuring that thing? So the airlines cases are a perfect example of this problem, I think, right? So you look at it from a straight up antitrust perspective. Aviv, Bill, we all looked at the American Airlines US Airways merger, and before us, folks looked at United Continental, and we looked at what the arguments were, and we thought about what the benefits to settling, as Aviv described, were, and we think we're doing this the right way, and we made the right decision. But a consumer who gets on an airplane today does not think we made the right decision. They feel their customer satisfaction is lower, that the airlines are, in some cases, beating people as they're dragging them off the airplane. So what is it that the antitrust piece is missing in this? Why does a transaction make sense from an antitrust perspective, but maybe not make sense from a consumer perspective? I don't know the answer to that, but that seems like a question that that's worth asking. The other thing that I think is a thread through all of this, and I agree completely with Debbie and Andy and everyone else who's talked about how much the courts matter and how much the decisions and the process of taking cases through courts and litigating them matter. And I think that's very true. I think how we litigated cases has changed over time, and that's also mattered a lot. Again, picking up a point from the prior panel, I think one of the things that we did much better when Bill and I were at the division was we actually explained our cases better in plain English in the complaints that we filed. There were upsides to that. I think people better understood what the concerns were. There were downsides to that. So for example, on the airlines case, everybody read the complaint. They said, that sounds like a really compelling case. Then you settle it, and we had a lot of people saying, I don't really see how that settlement matches up with the allegations of the complaint. But I think we have gotten to explaining ourselves and to explaining not just the economics and the complex economics. I mean, a great example is the decisions in the health insurance cases. You see Judge Bates actually, really taking hold of the economic models and actually describing them in very concrete terms. So that is part of the education, I think, and the part of the explanation to the world about how antitrust matters and what it can do for you. Leadership matters. Many of these cases might not have been brought at other times, so maybe we'll see. Sometimes it's not a Republican-Democrat difference. I think people have interests in different areas. Joel Klein was very interested in Section 2, so at that time the division brought a lot of Section 2 cases. Pay for delay is a perfect example of how I think leadership matters. The hospital retrospectives at the FTC were a perfect example of that. So who's in these jobs actually does make a difference in terms of the priorities that are set, the kinds of cases that are brought, and then the kinds of law that's made. I do think our discipline has gotten a bit technocratic, to pick up Bill's words. I'm not sure that I agree that that's come from the bureaucracy. I actually think in many ways that's come from the leadership and from the desire, perfectly legitimate desire of business to have greater predictability when it faces the antitrust division or the FTC. But again, this is going back to the are we measuring the right thing? I'm not sure we're capturing the full panoply of effects of transactions and conduct when we just look at data and when we just look at economic models. And I don't intend at all to reject the importance of those tools. They are very important and they tell us a lot about what needs to be done. But I think the simplicity of those economic models may be causing us, and the predictability and the ease for courts when the courts can say, well, here, I have actually something that will prove to you that this is a case that you should feel comfortable violates the antitrust laws. That does, I think, maybe cause our cases and our decisions to lose a little bit of texture that's important.
Thank you, Renata. I want to pick up on something that a number of you have really talked about. Debbie, I think you articulated best by saying case law moves over time. So I want to pick up on that in a way that sort of brings in a number of issues. Sometimes cases that now seem obvious, at the time were actually very risky. So seeing Bill Baer in the back, he can wave again. I remember that original Staples Office Depot deal that you blocked was a really risky deal to litigate at that time. In fact, most people thought the FTC had no chance of winning. It was a great case. I'm glad you brought it. I think of another great case, unfortunately, I don't know if it was a function of the judge or something else, that DOJ should have won under Renata in an earlier iteration of Renata, which was Oracle PeopleSoft. I think the facts were there. I think the economics were there. I think the judge got it wrong. But I think that also changed the way that the division approached merger cases. I think, likewise, since I'm talking about great cases, let me talk the other direction. I think the baby foods case was a disaster for the FTC. I think it was a wrong case. And in fact, I think it also retarded development of our efficiencies jurisprudence. And I think that that's important. So cases matter. How cases move matter. But bringing certain kinds of cases shape the next generation of cases. Think of test cases. Think of cases that had cases come even in a slightly different order. We would have had a very different jurisprudence develop. And I wonder if each of you could sort of work through some of the nuance of what you've seen over the years of how cases mattered that sometimes gets lost in the debate. That, let me be clear, comes from people from outside antitrust that don't understand, to tease at some of the points, don't understand the cases, don't understand the institutions, and really don't understand the nuance and textured history of antitrust. How do each of these factors really shape the development of antitrust? And I don't know who wants to jump in first. I'll take volunteers before I call on people.
All right, I'll start.
Thank you.
Sorry, I knew Danny was gonna tag me anyway. So, so I mean, I think losing Oracle PeopleSoft, starting with that, was important in a number of ways. So one was, I think it really made the division focus more on how we were thinking about unilateral effects and how we were talking about unilateral effects, and also the economics behind our unilateral effect theories. I think you saw that take shape in the 2010 guidelines. So it was an important push to really say, are we talking about this correctly? Clearly, this particular judge didn't understand it the way we think he should have, and if not, let's spend some time thinking about that and think about how to do a better job of that. So that was a moment of, I think, self-reflection and self-criticism that maybe we didn't do a good job explaining that. I think we looked for cases to fix that and ultimately found them. That takes time, so that's a downside, and that's a problem with having to do all of this through the courts. Again, the 2010 guidelines, I think, helped push things forward there. And then, other than the doctrinal side of that, I think when you lose cases, you kind of get afraid to litigate them, right? So it's a big deal for the government to sue someone, and if, I think John noted that there was a long series of losses over a period of time, the hospital cases, and I think people did start to think, are we really explaining ourselves properly? Are we picking the right cases? Are we doing this correctly? And I think that did lead to a period of relatively less litigation while at the Antitrust Division, we focused on developing our litigation skills. We worked on that a lot over the last 8 years with a new position for a director of litigation, a litigation DAG, hiring lawyers who were skilled in litigation, doing a better job marrying the economic side of the equation with the legal side of the equation, and actually really making sure those two matched up well in the cases that we decided to bring. So there's a lot you can learn, and there's I think a lot that can change somewhat incrementally and dynamically with the development of cases.
Yeah, if I can just add something, and I agree with everything Renata said. It always struck me, and I think some of my
a little closer to the mic.
Sorry. Yes, it always struck me, and I think many of my colleagues on the FTC, that if you win every case, you're being too cautious, and if you lose every case, you have bad judgment, and you want to be able to take risks, so intelligent risks, and you want to feel comfortable losing from time to time. And it's not empirical. This isn't empirical geometry, right? It is subject to a variety of judgment calls, even within the economic rigor that I think most times the agencies, and probably the other side as well, bring to the table. And so, when we were thinking about reverse payment settlements, and it really started at the end of Bob Potofsky's tenure and went right through Tim's and right up through Debbie's. There was a certain point at which we had lost in the Fifth Circuit, the Second Circuit, tamoxifen. We didn't really have good precedent in the Seventh Circuit. That was Acai Glass. And we held on to the thin reed of a Sixth Circuit decision that, as I recall, was written by an 80-octogenarian district court judge in D.C. sitting by designation. And the commission just decided that it was so important for consumers, and it was a collective decision, that we were going to sort of, push to see if we could get a case to the Supreme Court, and at the same time also support legislation which came oh so close to being, which was a rule of presumptive illegality, which came very close to passing as part of the health care bill. And so, that's sort of one of the things so going back to your question about sort of taking risks, you need to take risks, but that's one of the things I was most proud of the commission about. And I think another one was another area, and it really started well before my time, but under Tim, was looking, as Debbie mentioned, at hospital cases, right? And collecting information. And then starting with Evanston, and using the information we got in Evanston to become much more successful in that space going forward on behalf of the consumers you're supposed to serve. So.
Just to add on this, I think there's a real distinction between mergers, where the government is the ball game, and other areas of the law where they're not. The government worries. I mean, so on mergers, you know, unless I told the commission we were going to blow up Section 7, they just wanted to know what the right answer was for consumers. Because, yeah, there's a risk of losing. Nobody likes to lose. But you lose for consumers if you don't bring the case. So they didn't have a lot of patience for we could lose this case, was my sense. And so we would just bring cases where we thought the evidence showed that there would likely be harm for consumers. And if you lose time and time again, maybe people will retrench because it's a lot of resources being spent on a fool's errand if all you're doing is going into court and losing. But beyond that, there's not a whole lot of, you know, big picture risk in most cases to think you're going to do something that's going to harm Section 7 jurisprudence for the next decade. On non-merger cases, we're not the whole ballgame by any stretch of the imagination, and private plaintiffs bring an awful lot of private, you know, Section 1, Section 2 cases, and they have a very different calculus. You know, the client often just wants to get what it wants out of the lawsuit and isn't worried about irrevocably changing the law because it really won't matter to the private plaintiffs in most cases. And so, you know, I'm not sure that in every case the agencies are really the cutting edge ones that need to worry about. They can be more selective and are by nature. You can't bring every possible case. So they're very selective. And I think the case study approach, should we retrench, should we really bring this case or that case, comes much, much more into play on the conduct side, where sometimes the agency will say, maybe let's sit back and see what happens and where we ought to intervene. Maybe the best thing isn't for us to bring a case, but to basically get involved in an amicus case. I mean, I think there the government can be more strategic, and I do really think there's a difference in how they think about those sets of cases.
So I'd kind of like to ask a question.
And you're criticizing me for calling you professor.
I'll do that. If you look at merger decisions today, they are far more complex decisions than they were 30 years ago, 40 years ago. And in part, that's a reflection of where we have come in our thinking. And the merger guidelines have evolved on the argument and thinking, I think, that we should continue to try and make better and better guidelines that better and better explain what theories are. And I wonder from especially everyone else on the panel, did we go too far to the point where the government is now held to those guidelines? We sort of went from a period where we had to persuade courts to accept them to a period now where they create some very rigorous standards that the agencies have to meet. And that raises the cost of litigating and the calculus of litigating. And you can't imagine litigating without an economist, as Aviv was talking about earlier. Have we gone too far in trying to specify what a harmful merger is in a way that has actually constrained the agencies? If anyone wants to respond.
Bill, I'll let you both think about a response. Then you probably also had some other stuff that you wanted to say, so I'll let you deal with it.
Let me deal with the sort of the prior question. I think I agree with Debbie and others completely that mergers are different from other types of cases. And you know, if we look at the roots of this conference and why it is we're here today, I don't think it has to do with merger jurisprudence. I mean, to some degree that maybe filters in a little bit into the political debate. But it seems to me that fundamentally the discussion we're having here today traces back to the DA appellate losses. One was mixed, the appellate outcomes in the Microsoft case and the American Airlines case, right? Because those were the two cases in the late 90s, early 2000s that kind of rocked the agency back. that led to less adventurism in bringing Section 2 cases, essentially no adventurism in bringing Section 2 cases, that moved the Section 2 jurisprudence kind of in-house under color of Section 5 in the FTC, where you had a series of unilateral effects cases. But they were all, while significant in their own right, right? I mean, Unical and California Resources Board, Bristol-Myers Squibb, cases like that are, they're real cases. They really mattered for certain aspects of commerce, but they're not Microsoft, they're not American Airlines. And I think a lot of what we're seeing in the way of pushback today very much relates to the question, what are the agencies doing with respect to behemoth entities? I mean, it's very much a populist type of spirit, perhaps coupled with again, going back to the appellate cases we've seen in the Robinson-Patman area that have very much eroded the protections for small business. So, I mean, that I think is the root of the phenomenon that motivates this conference. With respect to Andy's question, no, I don't think we put ourselves in a box that way. I mean, I think that the perhaps the 82 guidelines or the 84 guidelines started us down that path, but as Jim Rill observed, the 92 guidelines were largely a response to case law, and the case law didn't come from so much from the 82 or 84 guidelines. I mean, that was essentially case law developed in the courts themselves, by the courts themselves. And it seems to me that that's the pattern that has developed. And if anything, the most recent set of guidelines sort of retrench from the prescriptive nature and have a more fluid, open-ended type of approach than the 92 guidelines had. So no, I don't worry about the phenomenon you described.
Let me let some others respond to Andy before actually we get to what Bill raised, because I think that is also really important. Any responses to Andy?
So I'll say two quick things. One is, I'm not sure I totally agree that recent case law is more sophisticated. Go back and read Brown Shoe if you haven't in a while. It has the concept of cluster markets in there before anybody was talking about cluster markets. It talks about submarkets, which are really in some ways, targeted customers. I mean, they have a lot in there, the way they think about geographic market, that is awfully close to how we think about it now. They just didn't have the economic tools to do some of the work. So yeah, there are some older cases that are just, I think we all think that Vaughn's Grocery is not a case that we would all write today. But some of the older ones really do stand the test of time, point one. Point two, no, I think the guidelines help us more than they hurt us. At least that was my perspective when I was at the government. Every now and then there'd be some silly issue. In Advocate, there was an epic debate over what footnote 4 of the guidelines meant. And I really thought, oh my gosh, has it come to this? Rather than sort of the big picture of what's happening. But on the whole, I think the guidelines were meant to explain to people how the agency thinks about things and frankly help educate the courts. And while the courts recognize they don't have to take it lock, stock, and barrel, I do think they find the fact that the government has told the world how it's going to think about things and then is telling the court, hey, this is how we think about it, you should think about it, helpful, as opposed to if the government just came in and said, do it our way.
Let me go back to Bill's other point, but just throw in some more things. So one is, for so much time, the Supreme Court cases that we did see in antitrust were private cases. They were not government cases, which I think shapes the development of case law as well. But it goes, I think, also to a broader narrative, Bill, that you raised earlier. Like, we're all priests, and There's the messaging within antitrust, whether it's to judges, and I take Renata's point very helpfully, that it's about how do we explain it to judges? How do we make the message? How do we build the capacity internally to win cases before judges? But the kind of things that you're talking about, Bill, have a different audience. It goes a lot to the questions that we asked in the very first session, right? There's a narrative out there that big is bad, and that somehow high-profile cases in high-profile industries matter more. Within the priesthood, have we sort of forgotten this? And how do we then retake the narrative to get people into the pews once again? John?
Well, can I just, in a small way and only partially, disagree with your premise? Because I am not, can you hear me in the back? Because I am not sure we've entirely lost control of the narrative here. There is no doubt that there is a cadre of people who believe, and who believe sincerely, that antitrust can be used to solve income inequality and to create jobs, and that should be part of antitrust thinking. And I think if you go back, I haven't looked at this in a long time, but if you go back to the Seller-Kefauver amendments, you'll see a little bit of that, or maybe more than a little bit of that. But I think to some extent this is really symptomatic of a bigger issue that we have in our society, which is that people, in the same way that people get their news from watching channels that reinforce their pre-existing belief, I think that to some extent this new antitrust, or as my former colleague Josh Wright called it, hipster antitrust, it's driven by sincere beliefs, and some of the things they're interested in, or they'd like to see. Some of the ways they'd like to see statutes change are worth discussion, but at the end of the day, I think to your bigger picture, one is I don't think we've lost control of the narrative. To your bigger question, first question, I don't think we lost control of the narrative. And two is, I think if we did, and if we saw major statutory changes, that would not inure to the benefit of American consumers. And that's what antitrust is supposed to be about.
I feel the need to defend myself, having worked on both Microsoft and American Airlines. So I don't want, because I actually don't think it's fair to say that those two cases are, what led to the fall of Section 2 enforcement. I actually think a change of administration had a lot to do with that, at least at the antitrust division. So this is, to my way of thinking, the lack of Section 2 cases over the 8 years of Bush 2, and not only that, but also the particular cases that were taken up to the Court of Appeals, like Trinco, which made it more difficult to bring Section 2 cases, had a real impact on Section 2 enforcement at the antitrust division, at least. I don't think it's fair to say that Section 2 enforcement's dead. People don't like to remember the United Slots case that Bill brought, but that was a great case, and that was a Section 2 case, which led to United abandoning an effort to get more slots at Newark Airport. So I think the challenges with monopolization cases in the U.S. Have to do with some difficulties with case law, which are real. The fact that these are very hard cases also to investigate and to bring, and if, as we were over a long, fairly extended period of time, faced with gigantic strategic mergers, the resources tend to flow towards those because they are urgent in some way. And also a real question within economics about what the right lines are to draw in terms of enforcing Section 2 and dominance more generally. I think there's been less uncertainty about that in Europe, but more in the U.S., and that's caused some impact here. I don't think we lost Microsoft either. I think we won that.
Yeah, and let me just add one quick point, which is sometimes you have to take yes for an answer. So it would have been really nice if we could have taken Intel to circuit court, right? But they settled. And it would have been, and we came very close to suing Microsoft for not honoring a FRAND commitment in a standard setting case. And then they backed down on the last sort of back and forth. And, and we ended up with a good settlement from the commission's perspective. So, there's a sort of random nature to what you can bring and what you hope to, and where you hope to make case law.
And we never got credit, in my view, when I was at the agency for good settlements. We were viewed only as enforcement-minded if you actually brought a case to litigation, even if you got everything you wanted to in settlement. And I thought that was a kind of a bizarre perspective.
Andy, you may have a wonderful book on Microsoft. Do you want to share some insights?
Actually, I want to go back to another point.
That's fine too.
Where you started. I think we in our field are suffering a little bit from the politics of our time. I don't think it's, and this goes back to something Bill said at the end of the first panel, I don't think it's very productive to try and label groups, the hipsters, not very helpful. It's a denigrating term. They don't believe big is bad any more than people calling them hipsters believe that big is beautiful. That's a way of sort of dumbing down and simplifying the debate, which we need to have. As Bill said this morning, I think that we should not be beyond self-reflection and consideration of whether or not we've got things right. That should always be a part of what we're doing as good professionals, as people in the field. So I think it would be helpful to move beyond it. There are genuine arguments to be considered, and the labels and the name calling isn't going to help. It just sort of forces us into the politics of our time, and we'll start tweeting at each other and not accomplish very much. So sorry for that, just felt the need. And Microsoft, yes, I have this really long book about Microsoft, and I think Renata's got a really good point that Microsoft actually never won any of the cases that were litigated against it. It settled and paid lots of settlements. It never litigated to victory. The evidence was bad. The case was well brought, and Renata did a great job working on that case. But it does show, I think, when you do want to take on that big case, it takes an enormous commitment of resources over time, and sometimes that time stretches across administrations. Those cases are difficult to bring, and sometimes you overlook the value of the little cases. I think if you look at a case like Lorraine Journal, there's no chance that the antitrust division that brought that thought it would be a case that we'd still be citing. It's a very interesting case on its facts and its theory, more sophisticated than its time. And the FTC's win in McWane is a very significant case to the Court of Appeals. It's got a lot of modern theory in it about exclusion. Those two little cases actually suggest that sometimes the agencies should not, if precedent is the goal, if a test case is the goal, should not be focusing on the biggest possible cases, because those little precedents add up and they make possible later cases. So those are good examples, I think, where smaller cases had potential big impact. And as big as Microsoft was, the case was not actually cited very much for years. And yet, when McWane was being briefed, the Microsoft case was really critical. When Justice brought Densply, the Microsoft case was really critical. And now, if you look at it, there's a group of 4 or 5 cases in the courts of appeals, all of which have relied on Microsoft. There was a time lag, but it turned out to be a very significant precedent. Although we wondered for years in doing our casebook, we put Microsoft in there and we said, how come no one's citing it? How come it's not out there? And it took the right circumstances, but it has now become part of the case law of Section 2, and it is the modern Section 2 case.
Bill, I want to let you have a chance to reflect now that we've had a little more discussion about your points.
Well, no, I mean, I don't mean to suggest that test cases need to be big cases, right? That's not the point. I mean, test cases can often be can be narrow cases. I mean, cases that establish significant rules of law often involve companies, the names of which were not prominent in society and are not prominent outside of the antitrust bar. The point I was raising actually goes more to sort of a collateral issue on Andy's point about the politics of the time. That if we think back to, again, what's motivating much of the activity we're seeing up on the Hill, it's not what's in the courts. It's not the narrow cases. It's that we have a large body of the body politic that is feeling disenfranchised, that's angry, that's feeling beaten down by, call it large whatever, large enterprise, large government, large stuff that is not them. They're large parts of the population that are saying, hey, where's mine? And you can call that an issue of redistribution, and to some extent it is, but it's also very much an issue of power politics. And that as much, I think, as anything else is what's driving the activity at the moment. And to that extent, it's not cured with small test cases. I mean, that's basically about the opposite side of power politics.
So let me take this discussion of cases, power politics. All of you are also in practice. All of you are also advising clients. And you see jurisdictions not the United States, and I'll throw in not Canada for that matter, whether it's in Europe, South Asia, East Asia, where you see a different set of assumptions, a different set of enforcement level that looks different than what we have here. Is that a function of sort of the politics of its time morphing in a different direction, or is that really the logical conclusion of what happens if we include these other factors? How do you, is this basically we're looking in the mirror, or we're looking in the funhouse mirror distorted? What are we seeing abroad?
Prior iteration, be that distorted.
All right, so apparently I have something to say about this. So I'm not sure I completely understand your question, but let me put it. I think there is some divergence, but I think there's probably less than people think there is. I actually think that what's going on here is, and Bill is right. People are pointing at large companies and saying we're being hurt by them, and that must be a failure of antitrust, because otherwise there wouldn't be these big companies if antitrust was doing its job. It's an overly simplistic description of what's going on. But in the US, I feel like what's happened is there's been a fraying of the social contract. So people talk about, that the share of profits of companies are more going to the owners of the companies and less to the workers, for example. And I think the power of labor in the United States has shifted over time and is probably at an all-time low right now. And people are asking the question of why that is and whether that's a good thing for us. So I think I fundamentally agree with Bill that that's what's animating a lot of the challenges there. Whether or not that's an antitrust problem is a different question in my view. I do think it's a very important public policy question, and I wish people would actually pay more attention to it rather than talking about how to modify the antitrust laws, because I fundamentally agree with what everyone has said about the statutes not being in need of change, but there are clearly some issues that we should be addressing as a nation. And I wish people were working on those more. But I don't know, maybe other people disagree. I don't see it as a funhouse mirror, I guess I would say. I'm not sure it's actually exactly a mirror, but I don't think it's a funhouse mirror. I think there are other dynamics going on around the world which cause people to abroad in Europe to and Asia to talk about what they're doing in dominance in a way that's very different from the way we talk about it. And their statutes and cases are different than we have here. So I think they have a little bit more flexibility than has developed here in our cases. But I don't think fundamentally they're driving at some different result, I guess. But maybe other people disagree.
I would just add, sometimes in this sort of divergence, convergence debate, I'd make 2 points. One is, I think it underappreciates the degree to which there are differences here. And we get differences of opinion between circuits. So it's not like there is a uniform, clear American view, especially when it comes to exclusion and exclusion-related theory. There's still disagreement about that within our borders. The second point is I don't always, I shouldn't say I don't always, I don't ever really like the way we've got used to talking about divergence and convergence. Divergence presumes there's a norm. And unfortunately, most of the time when I've heard that used by American antitrust lawyers, the underlying assumption is that we are the norm and somebody is diverging from what we do. And I think in the area of Section 2, if you look at a global assessment, we might be the divergent ones in terms of how permissive Section 2 has become in the jurisprudence. I like to think instead of adaptation that different societies have adapted these principles to their, whether it's civil or common law or other attitudes about regulation and government intervention. It's a complicated reason why you get differences across jurisdictions. I would agree strongly with Renata's point, though. I think in terms of glass half full versus glass half empty, there's an amazing amount, given how many jurisdictions there are now in ICN, there's an amazing amount of agreement on the language and the concepts. It's unreasonable to think that there would not be any differences of opinion. We have that here. We should expect it abroad. I think, given how quickly the number of jurisdictions has grown, it's quite amazing that we have the degree of interaction and agreement that we do.
I would just say I agree with everything that's just been said by you, Andy, and you, Renata. But I also think that if you look at some of those cases by some foreign jurisdictions, and notwithstanding great progress we have made towards sort of at least similar goals and similar approaches among a multiplicity of jurisdictions on Section 2, sometimes there appears to be a thumb on the scale against a successful American corporation.
Do you think the same criticism ever applies here when Europeans look at what we do, that we put thumbs on the scale in favor of U.S. corporations?
No, because we're making antitrust great again in America.
I got it.
I want to go back to something that Bill asked in the last session that I think is equally appropriate here. Any regrets? Either you didn't go far enough, or in retrospect, you wish you had done something differently, not gone as far as you did, one way or the other. Each of you have those regrets. Specific to antitrust law, I don't want to hear about prior dating history or other such issues. Renata, you were most recent out of government, so I wonder if we could start with you in terms of either things you wish you would have done or things you wish simply had come out differently.
So I'll just echo Bill and Aviv, and this isn't really a regret, it's more a question mark of whether we got it right in airlines. I think that's, the jury is probably still out, at least among antitrust people, but maybe not among the American consumer on an airplane these days. So that's one that I think about a lot. I wish we had managed to do something that I was trying to do at the very end, and that was to get rid of the vertical merger guidelines, which I think are horribly outdated and don't actually reflect the agency practice and
substitute in maybe just a more narrative explanation of how the agency thinks about, the agencies, I should say, since we're working with the FTC on this too, the agencies think about vertical transactions. I think that would have been a good thing to do, more clarity about vertical transactions. I know that's very timely. I'm not saying it because of the timeliness of it. It's just one of those things that we hoped to get done and didn't manage to do. And I guess the other thing is that, you know, it would have been nice to find a Section 2 case, and we didn't. So that would have been good.
Andy?
I worked in the policy office. Everything was great. Everyone agreed with everything. I don't really have any regrets, other than maybe we could have done more. But one of the amazing things about competition advocacy is that there was always consensus. I think in the 2.5 years I was at the Office of Policy Planning, there was only one time where a commissioner disagreed with anything that we were doing to advocate competition, and it was terrific to work with people like Debbie, and I just wish I had done more than I was able to do.
So for me, the great conundrum is settlements. It is really how the agencies enforce the antitrust laws, and it's what John said. Sometimes there were cases we wanted so badly to litigate because we thought they would make good law, and then the settlement came and gave us everything that we wanted. And what do? You take the settlement because you need to protect consumers, and it seems a little weird not to. So that was a challenge, and you know, we did the remedy study, and it showed that certain kinds of divestitures don't work as well as others. Really important to learn, but how you put that into practice, my nightmare deal was always, you know, something analogous to a grocery store deal, where grocery store deals have been shown to have some efficiencies. You know, we have experience with them. I represented grocery stores that claimed very clearly, we're going to get these efficiencies, and 2 years later told their shareholders we beat expectations. So you got to believe there was something there. But the scenario of two completely complementary grocery stores, and there's an overlap in St. Louis, and that's the only place there's the overlap, and finding a really good divestiture for that, because you know, it's maybe hard to find the big buyer. And so, you know, maybe the divestiture isn't going to be great. It's not an ongoing business. It's a handful of grocery stores in St. Louis. What do you do with that deal? You know, going in that on the whole, this deal is, you believe that the deal is on the whole complementary. You can't find other issues with it. It's an enormous deal, and yet there's this overlap in St. Louis, and you're nervous that taking the divestiture there may not be great for St. Louis, or make it even a smaller town, because it's usually even a smaller town. I never could figure out how to resolve that issue, and that one troubled me. I think it's something that people are going to have to continue to think about, particularly in light of the findings of the remedy study, that divestitures not of standalone businesses sometimes is important, have issues.
Well, one of the benefits of being GC is you don't have a vote. So I can't think of any decision that I personally made that I wish I had back. There are one or two or three sort of institutional decisions that I wish had come out otherwise. But those are the institutional decisions, not my own. But John was there for those.
So from my perspective,
accepting the invitation.
Actually, I remember a couple of times when you urged a vote that I wish you had taken back. But anyway, that's it. Or a non-vote. But involving, for example, a small oil and gas deal in a far-off state, which is the first time I remember you appearing before the commission. But that's neither here nor there. We got through it. No, look. I would say if you asked me would I have changed a couple of votes in retrospect, I would have. There was a case where I wish I had pushed staff a little bit harder to see whether, or an investigation to see whether there was a case. And it's in a sort of product market that's not unrelated to to what we're discussing today. It was a merger deal. But for the most part, if you can't, you know, the people I served with, including Bill and Andy and Bill, were terrific colleagues. And I think if you can't, you know, what was it, the Jesse Unruh? Do you know Jesse Unruh, the Jesse Unruh famous speaker of the California Assembly said, you know, if you can't, it was something like, if you can't eat their food, drink their liquor, and sleep with their women, and then vote against them the next day, you shouldn't be in this business. It's a totally inappropriate joke, particularly in this time of. Let me take. I redact that from the. Thank you. Video. No, but look, I mean, I think that. And again, I'm crediting Jesse Unruh with it, not anyone else. But it's just a quote. It's just a quote, right? But I do think that you know, if you you make so many decisions, and you did too, Bill, and they were, you know, almost as GC, and they were generally very good decisions. And if you have to, and of course you regret some of them when you are voting, but if you can't sort of, you know, look back and move on to the next challenge, then, you know, really you shouldn't be in the business of being a commissioner.
And Danny, I'm excluding budget and personnel.
So, related issue maybe is every once in a while, and this could go, in fact, maybe even to Microsoft and remedies, that some of the competition that emerges not what anyone anticipated. And I think you'd agree with that in terms of, you know, Yahoo or Google or Facebook or any number of other companies, or frankly, how 40 members of a compliance team at Microsoft couldn't seem to sort of work through some of the remedies. But there's a lot throughout antitrust that we just don't anticipate. Just at the time, just doesn't occur to us because we don't have the facts in front of us. What was, for each of you, maybe the final question was, what's the biggest surprise been from, you know, either when you were in government or even just to today? You just simply didn't think that something was going to happen one way or the other. Could be a case, could be shift in a particular type of market, could be the national rhetoric. Anybody sort of have a thought where you just say, wow, totally missed that one?
Election.
Okay. Other than that one, anything just sort of hot issues you just didn't think were going to be hot from an antitrust perspective? Maybe it's a tough question. Or maybe we just anticipate it all. I'll just throw in, I guess, one final thought, which is, after thinking about today's conference, you all probably have just a minute or two that you want to give some closing thoughts to react to either what you heard here, what you heard on the other panel, and then I'll do a quick little wrap up with, I promise will not be more than 3 or 4 minutes, and then I'd like people in the audience who stayed this long to maybe also participate and throw in their thoughts. John, you want to go first? Any wrap up thoughts?
Look, I'll go back to your last question, which is, I'm a little surprised today, but nothing astonishes me that the work that we did at the agency, at the FTC, I can't speak quite so much for the Justice Department, but the work that we did on antitrust when I was there and in the period after I left has become subject of such criticism by, and I think sometimes, going back to Andy's point, a little bit vitriolic. Because I actually think you do the best job you can, and you're not perfect, and you certainly make mistakes, but that, you know, we were trying to effectuate our mission, and we did it in a collegial way, and I thought in a fairly aggressive way too. But no wrap-up thoughts, no.
Yeah, I mean, revolutions and mobs can be dangerous, and I think we
need to take the current political climate as it relates to our discipline pretty seriously. Because as I began, there are, yeah, I mean, I don't worry about it too much through this time next year. But one more election, and I could easily imagine people hurling brickbats at people who share most of the views within this room. So yeah, I'd be paying attention.
I guess I'm surprised that so many think that the problem can be solved by antitrust. I mean, it's our little discipline. It's kind of, we always thought we were this, little world of a couple thousand antitrust lawyers, an antitrust division is with the big bad Justice Department, but, we always thought of ourselves as the little agency that could. We're much smaller than almost any agency there is, and the notion that antitrust is the solution to so many of the economic issues, I guess, surprised me, and certainly we have to think about whether there's more that antitrust can be doing, but as I often told the Hill, it's not illegal to be a monopolist, so please don't ask the FTC to do something about every drug price increase. I would hope that that the antitrust is not asked to solve all of the issues of wage disparity and the like.
So I don't think Senator Klobuchar really thought her bill had a chance of passing in the current Congress. It has done what it was probably supposed to do, which it has stimulated debate. And the new critics have stimulated debate. And it is just starting. It's not over. I think that I commend Bill and Danny for putting this program together, because this is going to be a live debate in 2018. It's going to be a live debate in 2020. I think our field has been put front and center, and we're going to have to think a whole lot more about how we explain what we do and whether there are areas that are in need of revision. And there is a danger of overpromising, I think, what antitrust can do, and that would be even worse. But this isn't going to go away. I think this is, like I said, just starting, and for a variety of reasons, antitrust is going to be in the center of discussion over the next few years.
I don't have any more surprises than the ones that were just listed.
I'll just throw out a few final thoughts and really open it up to all of you. So for me, I'm with Andy. I didn't think 3 years ago, I never thought we would have had this kind of debate and discussion. What is the meaning of antitrust? It was settled 3 years ago. At least that's what we thought. For me, that's the biggest surprise. And it's perfectly fine to ask questions. And I don't want anyone thinking that we shouldn't be asking tough questions. But I want to go back to something that Aviv mentioned earlier, which is that what helps us answer these questions is data. But I think sort of a precursor to what Aviv gets to is how do we think about the data? What are the assumptions that go into the data that we use and the data that we don't use? And this is a theme that we've heard a little bit, particularly in the last session. And so, as everything seems to be moving online, here's just the word of, I want us to think through our theories and make sure we have testable theories with good cases, and we got some of that here in this discussion. Some of it is let's make sure that the economic assumptions are right. The one thing that we seem to be missing, though, is let's make sure, for example, we understand the underlying technology. This comes into play in a lot of cases. Or expertise more broadly. A lot of times, though, it strikes me that the closest people get to understanding the technology is in watching a 30-minute rerun of The Big Bang Theory. And I think the challenge of antitrust going forward is a challenge that antitrust has had already, that it's had to deal with, which is how do you learn an industry where the industry itself is shifting? In a sense, this is nothing new. We've seen it before. It's how do we address it? So Bill talked about Mike Perchuk's speech, so I'll say this is like Silver Age movies of that time. Great movies. Easy Rider, Taxi Driver, The Godfather. I actually want to take us back a generation earlier. Golden Age. Citizen Kane, Wizard of Oz, King Kong, Stagecoach.
Danny, you sure we can't go back to The Godfather?
How about the original Scarface? The Hudson Hawks version. And I mention this because, in fact, it gets to something that Bill talked about just a little while ago, which is this sense of somehow there was inequality, somehow it wasn't working out for people. So if you think about the period of the Depression, and you think about the antitrust legislation that came out during that period, where again, there was a real concern about size. I'll use today's terms and go back to what we're looking at, right? We had a national firm that wanted to better optimize supply chain management. And that firm was not Blockbuster, wasn't Walmart, wasn't Macy's. Remember when people still shopped at Macy's? Remember when there still was Blockbuster? No, it's that other firm that some people remember, right? The A&P firm. And the original Robinson-Patman Act, again, to go something that Bill raised earlier, was the Wholesale Grocers Protection Act. That was the original title. It was very clear that it wasn't about consumers and lower prices. It was very much about a variation of industrial policy dealing with broader issues of democratization, that we liked small businesses, we didn't think that it was fair, and we're seeing this kind of thing again. And to Bill Kavasic's point of what would antitrust look like had Perchuk have been successful, we know what happened as a result of Robinson-Patman. There's no economic evidence that's ever been in favor of Robinson-Patman. And we've had some bad case law. Utah Pie, for which Bork had perhaps his most colorful language in the antitrust paradox, being perhaps one of the worst antitrust cases of all time. And to a certain extent, we've even seen this movie before, right? What we're seeing today is just current dislocation, people feeling uncomfortable with government in general, and we're seeing some of that in antitrust. But what happened over time goes to something that Debbie first articulated, I think, very eloquently about how case law should. Renata talked about incremental change in cases, and you see over time, Robinson-Patman shifts, all of a sudden it gets imputed into it a consumer welfare standard, all of a sudden antitrust injury applies to Robinson-Patman as it does in the Sherman Act. We get Brook Group that essentially eviscerates primary line cases. We get with Volvo fewer secondary line cases, and Bill Blumenthal, maybe the regret is that this SG never decided to say, have a nice brief that said maybe we should overturn Morton Salt and get rid of the Morton Salt presumption. Speaking of things that happened in your tenure, again, we're not your fault, and we can blame the SG's office, but in a sense, we seem to go through shifts where we've seen variations of all of this before, but in new contexts. And that's both exciting as practitioners, applying old cases like a Lorraine Journal to a high-tech industry like Microsoft. But sometimes it just leads to uncertainty. And so I leave us with that we've seen these kinds of struggles before, but in different contexts. And so it's an exciting time, but it's still an uncertain time. And with that, I thought I might get reactions from people in the audience now. We have 10 to 15 minutes where people can, you've been here long enough, you have your own thoughts that you probably want to share. Dale, I know you've been waiting to say something.
I don't have any thoughts.
This is the first time ever then.
All right, well, I will say something.
There we go.
All right, so I guess a couple of things. So first, I have to confess, I guess I'm just not plugged into the press, perhaps, the popular press as much as I should be. I mean, I hear I read The Economist and, see that there are these criticisms going on, but I don't see these on a scale that's any different than the kinds of criticisms that have gone on with antitrust basically for the last 100 years. I mean, you can't find a time in antitrust where there weren't critics. And sometimes the critics were much stronger, I think, than the critics are now. If you take a look at what the critics were saying in the 1980s about what was going on, it was at least an order of magnitude higher volume than it is right now. I also don't see the prospects of any significant legislation passing on the Hill, even if there is a change in the Congress. So I just don't see the problems the same way. So that's point number one. Point number two is, a little bit goes back to the question you asked on, I started with Andy, on convergence and divergence. I think one of the things that we've got to keep in mind is you really start the antitrust question on what are the policy goals of the antitrust, which is a political judgment. So if, for example, you're in Europe in the 1980s or the 1970s, the biggest objective you want to accomplish is the integration of the markets. And you're not that interested in promoting efficiencies through efficient vertical relationships if they're going to harm the integration of the market. So you come out with an entirely different antitrust law than you do when you're in the United States, when the United States in the 80s were saying efficiencies drive things. So that's one question. Second question is, if you're going to change the law in some way, do you have an operational standard to actually implement whatever the policy goal is? And the third one is, do you have the right agency to do it? So I can imagine, for example, I think it's a perfectly legitimate question as to whether or not some of the drug prices are too high from a public policy perspective. But even if you agree with that, and even if you think, like Gary First has suggested, Section 5 might be able to reach that, that doesn't mean the antitrust agency should be the ones that do it. I mean, the last thing in the world I want to see is antitrust officials thinking that they know something about how to set prices. Because once you have that mindset, it's going to influence everything they do.
I don't know who might want to take that first.
Yeah, that's right.
Someone who perhaps served in a Democratic administration.
I don't disagree with any of that. I think there's real danger in trying to funnel lots of society's problems into the antitrust agencies and the antitrust laws. So I agree with that. I don't know how the agency would set drug prices. So
I mean, I guess I agree with you on the pricing point. I do think there's something a little bit different about this current criticism, and maybe it's just because it seems like it's directed at a time where I served, but it seems to be suggesting that antitrust enforcement is the thing that has caused, or a lack of antitrust enforcement over not just the last 8 years, but over a long period of time, is the thing that has caused all of the ills that ail the country right now. And I don't think I remember, maybe I'm not that young, so I don't remember a time where that was the kind of criticism. Often there were false positive, false negatives, not enough, too much. But really something that's talking about antitrust as being the driver of the discontent that many people feel in the country. I think it's a different tone, I guess.
Can I ask just one question on that? I mean, I read the press. I don't pretend to be the most educated person in the world on this stuff. But I just don't see that view gaining any traction.
Oh, I'm not sure it's going to gain traction.
No, but there's always people that are out there talking crazy.
Dale, here's what I'm reacting to. I'm not focusing so much on Klobuchar statements out of the Hill at the moment. What I'm focusing on is that there is a level of populism that exceeds, I think, anything I've seen, at least in our adult lifetime, right? I mean, and it's bipartisan. It's not strictly, it's not across both parties, but there are big pockets of it within both parties. And the populism has gotten bound in with antitrust as a component. I don't see that there's any significant likelihood that antitrust could be used as a meaningful vehicle to achieve say redistribution. I mean, people may try, but I don't see that there would ever be a successful effect. But to the extent that one envisions a new Section 2 style attack on bigness, to the extent one envisions, say, some sort of conglomerate merger bill a la Hart, in the late 70s, to the extent that one envisions, very much of a Robinson patent and rehabilitation. I could see a lot of that happening, and I think that many of the efficiency benefits that have been achieved through modern antitrust would be to some degree imperiled if things go in that direction.
I can see a lot. I mean, I can see what you're saying. I think it's just where I think we might just have a bit of a disagreement is how strong are those forces actually in the political environment? I think that, but it certainly is true that if when you have an evidence-free, sort of fact-free, rule-free kind of world, I mean, anything can come out. So I agree that that's a concern. I just don't see these particular, concerns that have been, expressed, whether it's by, Senator Klobuchar or whether it's on The Economist, or really getting a lot of traction and forcing a sea change in antitrust law in the foreseeable future. That's my only point.
If you haven't had a chance, Dale, to take a look at Carl Shapiro's Antitrust Populism, he does, I think, a really good job of trying to gather these sources together in the front part of the article to show that it is widespread. Whether it will amount to anything, I don't know, but I think it is. I agree with Renata. It's different in character and kind than other times when we've seen
And that
this.
difference is because of its scope rather than its intensity?
I think
you guys didn't live through what was going on in the 1980s, right?
Well,
but I think both. Yeah.
I think it's the context more than the scope or the intensity.
Yeah.
Bill Kabasik, I see your hand is up.
In part, maybe just to say some thank yous.
Yes.
If I could. Yeah. We had two wonderful members of the administrative staff here who made everything that we've done possible. Perna Balasundaran put together our program, did all the logistics, and she did it with Kiera Hannon, who's my faculty secretary, who was indispensable to doing lots of the planning for the event. So I'm deeply grateful to both of them for this. I'm also grateful to all of our panelists who came and willingly decided to reflect on their past work and to think about the future. And one thing that I would like us to see if we can find ways of thinking about it's responsive in many ways to Dale's comment, is how to carry the discussion going ahead, how to think about how some of the insights from those who've been involved inside the enforcement process would bear upon decisions about what to do, especially to the extent the legislators are doing them. I've noticed in my own experience a considerable difference in perspective from those who have been inside the agencies doing work on specific projects and those who have not. Whether it's the wisdom of a broad public interest mandate to be applied to competition law, whether it's the incorporation of a variety of other goals, the difference between the experience of observing from the outside and doing it on the inside is striking. And I think when you take the groups who've been inside the institutions, they have a different view about what we referred to earlier as administrability, simply the manageability of doing the process, carrying it out. A final thought is for those of us who were at the FTC in the late 70s, who did watch the effort to implement the full-blown program. And it was an extraordinarily ambitious effort to do many of the things that we're talking about, with taking direct account of many of these factors. One thing you see is how hard it is to try to carry this out. and arguably the commitments that the agency made greatly outran its capabilities. But the other is not to account for the political feedback loop. What happens if you take on all of these issues with a broader conception of policy? Legislators feel far more willing and able to intervene in your affairs. You look much like the Federal Communications Commission, which has been the subject of a lot of study with the public interest standard. Congress feels as though they own that process and that they feel no inhibition to diving into it and running that. So the broader the focus of the agencies, the greater the likelihood you will have fairly intrusive political involvement. And the way our system operates simply reflect on what would drive that involvement. And second, inevitably, is that if you strike at a larger number of major business enterprises, that larger political involvement will take place. It's not a formula for timidity, but just to recognize in our system, the way we fund campaigns, the way in which the political process operates, resources are mobilized to oppose the institution. And the case study of the FTC and what it went through in 1979, 1980, before Ronald Reagan comes to Washington, that's when the real damage to the institution is done in many respects, is a testament to what happens if you're not cautious about the consequences of taking on a number of these issues. It's an explanation for why competition agencies in many ways have tried to narrow the focus and in many ways to preserve their independence by limiting the range of issues that they take on. My thanks again to all of our participants.